Live from beautiful downtown Toronto at the world-renowned and utterly amazing Inclusive Design Research Center at the Ontario College of Art and Design University. This is Canada's first conference, International Experts Policy Conference on what should Canada's promised national accessibility law include. My name is David Lepofsky. I'm a visiting professor at the Osgoode Hall Law School. I'm also chair of the Accessibility for Ontarians with Disabilities Act Alliance. Today's conference is being brought to you by the Alliance for an Inclusive and Accessible Canada, a coalition of major national disability organizations which has united to bring forward the voices of people with disabilities as the Canadian government develops the accessibility law that it's promised to deliver at the end of this year or early next for debate in Parliament. For American Sign Language interpretation or real-time captioning, these will be available on your screens. If you want to see the bios of our speakers, they're available at alliance-canada.org. And if you want to tweet about our event today, you can use the hashtag #Accessible Canada. My Twitter handle is @David Lepofsky, and the Alliance's Twitter handle is the Alliance CA. So with those words of introduction, I'd like to briefly call on Barry McMahon, the chair of the Alliance, to bring us words of greeting.
Thank you very much, David. On behalf of the Alliance and on behalf of the Council of Canadians with Disabilities, I'd like to welcome everyone. This is quite an exciting event. The Alliance, as David said, is a consortium of 12 disability consumer groups and service organizations, and it was tasked by the ministry to do consultations with Canadians about what should be included in the new act, the problems, and how to remedy the problems. We have finished 28 consultations across the country in communities outside the main target communities, and we've heard a lot of really interesting concepts. Hopefully today's ideas and advice can be distilled, and we're going to be doing a further 100 targeted interviews with invited participants, and hopefully we'll be able to test some of the ideas that are going to be disclosed today. And hopefully we'll build a truly forward-thinking, innovative, and effective new act. Now back to David.
Thank you very much, Barry. I want to also acknowledge with thanks a grant from the federal government to the Alliance, which has financed its consultations and very much assisted with this today's event. I also want to acknowledge with thanks the amazing support of OCAD University's Inclusive Design Research Center, particularly with the technology that lets us get to our subject. So let's get to our subject. Just a few moments of introduction, and then on to our first speaker. In 1982, Prime Minister Pierre Trudeau delivered to Canada its Charter of Rights. Initially, the draft of that Charter of Rights did not include equality for people with disabilities, but during the debates in Parliament, equality for people with disabilities was added as a constitutional right, the first written constitution in the Western world to explicitly do so. And it did so in response to calls from we, people with disabilities. Similarly, the government of Pierre Trudeau enacted the Canadian Human Rights Act, which banned discrimination because of grounds such as disability. But decades later, over a third of a century later, these important rights, while fundamental to us, have not been translated into full equality and full participation for over 4 million Canadians with a disability. This is in no small part because to enforce those rights, individuals with disabilities have to bring claims, legal claims, one organization at a time, one barrier at a time. We need something better. We need a new law that will not replace those rights, but which will make them become a reality. This is an international trend that started in 1990 with the Americans with Disabilities Act, fortified by the UN's adoption over a decade ago of the Convention on the Rights of People with Disabilities, and paralleled by the enactment of national accessibility laws in various countries around the world. 2 years ago, in Canada's most recent federal election, people with disabilities called on all the federal parties competing for our votes to promise that they would enact a national accessibility law. Some of the parties made that commitment. One of them is the Federal Liberal Party, led by Justin Trudeau. Having won that election, the Justin Trudeau government, to its credit and with our commendation, has acted on that commitment. First, it appointed Canada's first ever national minister responsible for people with disabilities, the Honorable Carla Qualtrough. We are honored that she will be attending our event today. She's delayed by a cabinet meeting she has to be at the very start, but we'll let you know when she arrives. And we are also honored to have her Deputy Minister of Labor, Laurie Sterling, here to learn from us today. Also to the credit of the federal government, they have undertaken, I believe, Canada's biggest, broadest, and most effective ever cross-country consultation on the barriers facing people with disabilities, all to assist the government in deciding what to put in this legislation that it promised. We've heard that they are aiming to get that bill before Parliament by the end of this year or early next year. We know they're on the verge of making tough decisions, so we've offered this conference today. We want to tackle not the question of why we need a law or whether it's a good idea. The federal government's already convinced of that. We want to tackle the tough policy questions. They include these. How do you define disability? How do you make accessibility standards to govern federally regulated activities like banking, air travel, telecommunications, federal government services, and the like, so that they actually achieve accessibility? Also, how do you enforce this law so it really works? And finally, how do you use the other levers of power, such as the federal government's great spending power in the marketplace, to leverage as much accessibility as we can? Those are the issues we are going to address. We commend the federal government for its commitment to work towards adopting the optional protocol of the Convention on the Rights of People with Disabilities. This will all reinforce those discussions. So, my role as your moderator today will be to invite each of our speakers, international speakers, Canadian speakers, to help guide us on these questions. I'm asking the questions, and I want to make sure they're tough questions to give the government the best advice that we can. So thank you all for coming. Let's get to work. The first topic I'd like to turn to is the question of how we define disability. Our first speaker available to us from Lucerne, Switzerland, is Professor Jerome Bickenbach. Jerome Bickenbach, who is from Canada, initially studied law and philosophy here, became a professor at Queen's University, but is now a professor at the University of Lucerne. He has written the defining books on how to define disability for purposes of disability policy, and he's had a chance, particularly posted in Switzerland, to view this issue from the perspective of what's going on, not just here, but around the world. So, Jerome Bickenbach, I trust you can hear my voice. Good morning from Toronto.
Good morning, David. We can't keep meeting like this.
I agree. I totally agree. I want to jump in to our questions. Okay. So I want to ask you, your advice for the federal government what's the best way to approach how to define disability for purposes of a national accessibility law so that it is effective at protecting the rights of Canadians who have a disability?
David, as you're well aware, in the legal definition domain, there are various pitfalls and traps that is very important to avoid. And I want to make a case for essentially the definition, or maybe it's better to say the characterization of persons with disabilities that's in the convention, or I will call it the CRPD from now on. In the convention, in the Article 1, the purpose section, after considerable debate about whether you should specify in intimate detail the specific impairments, the specific range of severity of impairments, the longitudinality, whether they should be temporary, episodic, or on all these details, which can only, in my mind, prevent the widest possible application of an accessibility law. They came up with this, which I'll just read. Persons with disabilities include, very important word, include those who have long-term physical, mental, intellectual, or sensory impairments. Now here's the key, which in interaction with barriers may hinder their full and effective participation in society on an equal basis with others. Now what I'm stressing here is something which in the literature we tend to call the social model of disability, which is to say that disability is not in the person's body. Disability is the consequence of a person with impairments of various sorts, which, because of barriers in the environment, limit their participation. A characterization such as this is certainly as broad as you could possibly imagine in any formulation, because it is completely non-specific with respect to specific forms of mental conditions or impairments, but it hits on the key idea. The key idea is that inaccessibility creates disability. So that focuses our attention not on the person, but on the barriers in the environment that limit the person.
Now, I'm gonna challenge you on this because in my role as host here, that's my role. And I'm gonna suggest to you that that CRPD definition is helpful, but that it doesn't go far enough. Because and I'm gonna put this to you to get your feedback, if you can. I agree with everything you said about social model of disability being the approach that is most desirable. But we want organizations to know what they got to do, and we don't want to have skirmishes where anyone is saying, oh, that condition, that's not a disability, I don't have to do anything. To that end, in Ontario in 1982, when it enacted the Ontario Human Rights Code, and in 2005, when it enacted the Accessibility for Ontarians with Disabilities Act, on the recommendation of those of us who were community advocates, we wanted it to be a broad definition, but we wanted it to include, without limiting it, the conditions that we knew we wanted organizations to be alive to. So if you look at those definitions, they list a range of physical conditions, mental, intellectual, sensory, neurological, and otherwise, so that there was no fight at the door. So I want to ask your thoughts about that. We've learned from the US, where the Americans with Disabilities Act has too narrow a definition, that created problems, but we in Ontario have not had a fight at the door under our Human Rights Code or our Disabilities Act on who has a disability, or that it has suffocated it in too narrow a term. Can you speak to that? So what would be your response?
You're hitting on several points at once. I mean, jurisdictionally, if you are confident the Canadian judges at various levels in interpreting this legislation will just be broad-minded, and they're good Canadian souls, and they won't be engaged in the kind of reading down which is characteristic of both of the American situation and also other countries. Then you're, I mean, we're as Canadians, and I feel that I am still a Canadian here. That kind of optimism is probably justifiable. But if one has as we say in French, un soupçon a little bit of caution here. Anytime you specify in detail, and I'm reading from the AODA, epilepsy, brain injury, degree of paralysis, whenever you specify that kind of detail of impairment, and in some cases health condition, what you're opening the door to is a kind of interpretation that says, well, first of all, I don't find your problem on this list, so you don't qualify, even if you have an open-ended, not discounting the generality of the definition, etc. And you open, it seems to me, you open the door to a kind of investigation which is entirely beside the point. Because the point is not what kind of situation the person's in. That, in a sense, is irrelevant. The problem is what the barriers in the environment, attitudinal, social, policy barriers, physical barriers, accessibility barriers of all sort. That's where the problem is. Now, if you have a kind of characterization that the CRPD comes up with, and I must say, comparatively speaking, most countries are gravitating toward, if you have a very general, open-ended, not even definition, but characterization, then that first hurdle, why should I give you accessibility? Because you're not really a person with an impairment. That kind of obstacle vanishes. Now, I understand your motivation for this, and perhaps one alternative is to have this general characterization followed by, perhaps not in regulations, but followed also by these kinds of more specific identification of impairments. I still think of that as a potential pitfall that can easily be avoided.
So what we're talking about is a possible hybrid. We define disability in terms that they use in the Convention on the Rights of People with Disabilities. And then we go further to say, for example, but not in any way limiting that definition, are the following, so that people don't have to worry about fighting or arguments later or having to go to court to prove that they're in.
Yeah, can I, sorry, I'm so used to interrupting you, David, from our past lives together. I'm continuing to do so.
You interrupt, and then I end up being right, but go ahead.
We're two old lawyers. But just to make another point, you introduced this in a very, very important way. In Europe, we say equality is anti-discrimination plus positive action. And what you do is you have an anti-discrimination regime in place, which is compensatory in form. That is to say, a person, his rights have been violated, and you compensate with respect to that. But the other half, and increasingly more than half, of state action, which is emancipatory, if you like, is positive action, anticipating the creation of and preventing the creation of barriers in the environment, which are doing all of the bad work here. The impairments aren't doing the limitation of participation so much as the barriers that are created by lack of access. So if you're crafting an anti-discrimination statute, then you might want to be very, very cautious about who qualifies to use this, so that you don't have overlap with other kinds of anti-discrimination marginalized groups. But if you're looking for a positive action, a forward-looking way of reorganizing society so that as a society, it is universally designed for the maximum amount of participation for the maximum number of people, then you downplay the entrance requirement of being a person with impairments, and you play up the features of the environment that you're addressing. An Accessibility Act addresses the environment, not the person, because that's really where the action should be.
And so I'm going to hit you quickly with one point that I thought was especially helpful when we spoke in preparation. The Ontario Human Rights Code and the Ontario Accessibility for Ontarians with Disabilities Act talks about conditions which are caused by birth defect, injury, or illness. And you pointed out that leaves out an important additional cause that we should consider including. Can you talk about that?
That's very nicely primed for my aging mind. Yes, I mean, increasingly, I used to work at WHO, and WHO made projections for the future, given demographic aging and the switch from non-communicable disease toward more chronic multimorbidities and other such things. And what we're seeing is that in the next 20 to 30 years, probably between 50 and 55% of the persons with disabilities will be over 65. So there's an aging of this population, and that really should be taken into account, because people who are aging are acquiring various forms of impairments, but not in the way which is characterized typically by lists of these diseases and conditions. So what you want to add, if you're going to be adding specific determinants of the status of disability, should actually be aging as well. Because increasingly the aging population and the population of persons with disabilities, since they have identical assistive technology requirements, identical accessibility issues, they really should be merging their kind of their focus, as in fact the United States is making the move with its recent reshuffling of NIDLR and other kinds of agencies, because aging and disability really are conditions which bring the same kind of accessibility issues to them. So yes, thank you for reminding me. I would add aging.
There you go. All right, thank you very much. We appreciate your contribution. We hope you'll stay tuned. I want to now move to our next speaker. We're now going to talk about Canada. We've had an international perspective. We're going to spend about the next hour, or maybe a little longer, talking about what we've learned in Canada. And I want to begin by a real nuts and bolts topic, and that is setting the rules for our built environment to ensure that it's accessible. And to speak to that, at the table with us, we have Thea Curdy. She's an accessibility consultant with Designable Environments, just working in the Greater Toronto area, situated there. This is an organization which works on consulting with architects and others designing buildings on including accessibility in their designs, auditing buildings for where there are accessibility problems, and helping draft accessibility codes or regulations or bylaws for some municipalities here in Canada. So very much in the front lines. So Thea, thank you for joining us this morning. People start from an assumption that old buildings were built back when before we knew about how to design an accessible building, but now that shouldn't be a problem. A new building built here today in Canada, it should be expected to have no accessibility problems, because we've updated our building codes and our architects are trained at our fine universities. Is that so?
Unfortunately not. The reality is there's a huge gap between what our regulations require and what the Ontario Human Rights Code is asking for in terms of real equality in the built environment for people with disabilities. And unfortunately, the training for everyone in the design profession and the construction profession doesn't really address people with disabilities as people first yet. It's still very much an afterthought type of training. So we design for able-bodied people, and then we'll consider some add-ons for these other people.
So let's first talk about where we're at in Ontario, if you could help me. We have the Ontario Building Code, and it was updated again in 2013, 8 years after the Accessibility for Ontarians with Disabilities Act was passed, and we have limited accessibility regulations dealing with public spaces. That's either areas where you serve people in buildings, or outside parking spaces, recreation trails, and so on. Can you give me some examples where someone could build a building today that fully complies with those, and yet there's an accessibility problem? Can you describe the kind of deficiencies in a building that we might find because those laws don't go far enough?
Absolutely, but I'm going to start by correcting you. The Ontario Building Code is actually just updated on July 1st of this year. So there weren't a lot of changes to it, but there were some accessibility improvements to it.
News to me, because the Ontario government didn't ever talk to us about that or seek our input.
Interesting. Okay, so for example, one of the things that we've done recently is we've been going out to the community to try to help people better understand this issue. So we looked at a site plan, for example, and if we look at what the Ontario Building Code and the AODA requires for that site plan, there are generally about 4 or 5 different items that you might have to include. So the accessible parking, a drop-off area, the accessible playground that you might have, and the path of travel to get onto the site. And those are all good things. But if you looked at other accessibility standards, and because we write them for every level of government and internationally as well, you can see the comparison we do for it has 12 or 15 different things that you might be considering. So the directional wayfinding signage on the site, at decision-making points for people who can't see, directional wayfinding, tactile surfaces on the ground so that you can find your way to the front entrance from each of the starting points, where the bus stop stops, for example, or getting from the playground to the front entrance. And then things like an animal relief area. So if you have working dogs or working animals who are assisting people, where do they go to the bathroom on the site? And how far is that from the front entrance? Rest areas are required in the AODA for people to have a place to rest if they have some stamina issues, perhaps. But they're not detailed as to what's required of them. So the design of them is put onto a public consultation. So for each project, we have to go and have a public consultation to ask people, what do you want for these rest areas? So that doesn't create a continuity of design. You're not going to find the same answers in each of these. And one of the things we find about accessibility is predictability in the results is a huge benefit to people. Color contrast is another one. It's a big thing. It's not a big cost, but it is a significant improvement for people who are losing their vision or have vision loss, to be able to find the front entrance, to be able to find features that we're providing for them.
And these are features that the Ontario Building Code now does not adequately cover.
Right.
Okay, if I could turn your attention now to the National Building Code, because the National Building Code, which is created in the federal sphere, it sets standards for design requirements for buildings in the federal sphere, but also provinces can use it either to create their own building code or just simply adopt it. Is it better or worse than the Ontario Building Code for accessibility?
Well, the National Building Code actually is the start of where the Ontario Building Code always works from. But the good news for Ontario is that we've gone further than the National Building Code.
So the National Building Code is actually worse.
So the National Building Code has less accommodations for people with disabilities. For example, although they require universal washrooms, they don't require the same number of universal washrooms that we have in Ontario. And a universal washroom, for those of you who are not familiar with the term, is a space that's not only an accessible individual washroom, but also has this space for an adult change table. And this is, a great innovation. Unfortunately, the Ontario standards don't yet require the change table to be in the space. You just have to provide the room for it, so that can cause some problems. But they're often in the National Building Codes smaller dimensions. So, for example, the clear width for a door, the path of travel, and the clear width on a ramp is reduced in the National Building Code compared to the Ontario Building Code.
So, just because time is short, I'm going to move fast. There's an organization which is not government called the Canadian Standards Association. They've created a built environment standard, which is optional. If an organization wants to follow it, they can. Is it the solution, or does it fall short?
Well, the CSA B651 standard, which again was adopted initially in 2012 but was updated in 2015, has a lot of really good ideas in it, but it doesn't require how many of those ideas you have to provide. So, for example, an area of refuge. So if we're looking at equity of fire safety.
What's an area of refuge?
So equity and fire safety, if the fire alarm gets pulled, what do? We're not allowed to use the elevator. So where do I go as a person who needs to evacuate from the building or find a safe place to be? Where do I go to do that?
If I can't use the stairs.
If I can't use the stairs. Now, areas of refuge in the building code are not required if the building is sprinklered. But if we add water to fire, we get smoke. and smoke's what kills people first. So an area of refuge is a smoke-free protected environment that has two-way communications so that you can be in contact with the fire department when they arrive on the site to identify where you are located. So the CSA has got that kind of information, but they don't tell you how many areas of refuge that you need. For example, one idea is to have it in every exit stair. So equal travel distance, just like for an able-bodied person, to get to an exit stair. And in an exit stair that really is 3 feet deeper on the landing. So you could go into the exit stair, but stay out of the way of everybody who's actually using the stairs.
So the CSA proposes this. Why does it fall short?
So it doesn't tell us how often we have to use it or where we have to use it. So it describes an idea of something, but it doesn't prescribe how many you have to provide.
Okay, so let's look to municipalities now. Some municipalities some of them working with your organization, and some not working with your organization, have developed their own local building codes or standards for their own municipality. Are they any better?
They're quite phenomenal, actually. I'm really proud that Designable was the consulting firm that worked with the City of London to create their facilities accessibility design standards in 2001. And what was great about what London did is they consulted extensively with people with disabilities, and they made their standard available for free on the internet. And that allowed more than 100 communities to date to adopt their standards as their own standards. And these accessibility standards are really looking at trying to address the gap that we see between the regulations that we currently have and trying to approach what the Ontario Human Rights Code's asking us to achieve.
So if you were designing a new standard for nationally, would you pick and choose from all of these or elsewhere, or is there one out there you just take off the shelf?
No, there's no one standard yet that I've found that I think really completely addresses it. One of the things about when you create a standard or a guideline is that you're creating it by committee. Instead of looking at evidence-based design, what do people actually need? It's a negotiated settlement. That's why these numbers are different. Why is the clear width for a door opening in the National Building Code 810, but in the Ontario Building Code it's 860, and in the municipal standards it's 900 or 950? Why are these numbers all different? And that's very confusing for the design community, frankly, that there are so many different municipalities with slightly different numbers and slightly different requirements that we desperately need to have a standard that everybody can use. The CSA is great in a lot of ways, but it could learn a lot from what the municipal standards are doing.
Okay, last question, and just briefly, when you're working with architects or other design professionals or a client organization that's designing a project, and you urge them to do something more that's in the building code of the AODA standard, what kind of reaction can you get?
Well, because they haven't been trained to think about these types of accommodations from the very beginning of their career, this is something new to them. And in many cases, it's not exactly their style. And that's not the way we're used to doing it. So there's a discomfort in it as well. But often we're finding that in a competitive bid environment, where you're trying to compete to win a job along with somebody else, then the fear is if we do more than the allowed minimum, then we're going to be outbidding ourselves from this project. So there's that fear that they're going to lose the job if they try to do more. So that principally, I would say that that's the resistance rather than not wanting to help people.
All right, thank you very much, Thea. I want to now move us to think a little, to go broadly beyond the specific barriers in the built environment, which relates to a certain range of disabilities, more broadly. So Ontario, to its great credit, passed the AODA in the year 2005. It requires Ontario to become fully accessible by 2025. It requires the provincial government to develop and enact and enforce all the accessibility standards needed to get us there. And we'll hear in a few minutes from the minister who led the creation of that law. But first, under that law, one of its many strong points is that it requires the government every few years to appoint someone to do an independent review, to take our temperature. How are we doing? Are we going fast enough? What more do we need to do? There have been 2 such independent reviews in Ontario. The first was conducted 4 years after the law was passed, and it was conducted by Mr. Charles Beer, who was immediately to my right. And the second review was conducted in 2014 by then Dean Mayo Moran, now Provost Mayo Moran, who's sitting 2 seats over to my left. By the way, immediately to my left is Wendy Porch, who is making sure my mic is on, and thank you for keeping me in line. So we're going to talk together, the three of us. They've each done an independent review. They each had to consult the public and then offer their independent advice. Charles Beer brought to this the expertise of someone who had been a cabinet minister in the Ontario government in the 1980s and had a real understanding of our needs and of how government works. Mayo Moran brought her expertise in the law and her experience running a law school and having to understand what it means to deliver real accessibility to staff, faculty, and students. So first, we're going to talk together. Charles, thank you for being here. Tell us, how did you reach out? You were required to consult the community, people with disabilities, business, and other. How'd you do it? And who'd you talk to?
Well, first of all, thank you, David, for being here, as well as a number of the rest of us. And as has been noted, we've all at different times had conversations with you, perhaps some more aggressive than others, but all where we learned a great deal. So I think one of the things that is important to understand with the first review was that when Ontario brought in the AODA and passed it in 2005, there was tremendous excitement in not just in the community, the disability community, but a real feeling that this was something that had moved the yardsticks. And so as we sat down to figure out, okay, how do we begin to reach out, we realized that it was terribly important that we did things not just in the sort of traditional sense where you have some public meetings in specific places, you ask people to send in submissions. I mean, we had to do that, but it was really, how do we make sure that we've reached out to people throughout the province, and again, not just in Toronto, Ottawa, Hamilton, the larger centers, to really hear people's views. So, as I say, we did the traditional things, but I think there were a couple of things that I just note that we found really helpful. One was we created 4 roundtables because of the time when I was doing my review. The 5 standards that the province was developing, only one had actually been implemented. So there had been a lot of questions around the process that led to the development of the standards, and that was one of the things that I was asked to look at. But it meant that in the area of transportation, the private sector, the accessibility groups and representatives themselves, and then the broader public sector. There was an act currently in place when we were doing this review, which was the original Ontario legislation that dealt with disabilities, but it had only applied to the broader public sector. So we had special sessions with representatives from the transportation sector, from the private sector, from a range of disability actors.
And these were closing roundtables.
Yes, yeah. And one of the things we'd been told, and one of the reasons we wanted to do it, was that we had been told that some felt that in the process they'd had to go through, there hadn't always been as open and free a discussion. And so what I was trying to do was to say to everybody, look, you can say anything in here. It's not that I was going to attribute comments, but I really need to know how you feel about, what is happening, what are the things that are working, what aren't working.
Okay, that's good.
And those were really critical. And then just quickly on the other piece was really trying to use, now this is 2009, 2010, but the technology that existed at that time to reach out to people in far-flung communities. And so we were able to do a number of different kinds of consultation that included smaller numbers of people, but we did more of it. And that really helped us tremendously in the north, in rural areas, and we were able to do it in both languages.
Okay, Mayo, I'm going to turn to you and just say, because I want to get to what you folks actually found, but are there any steps in addition to that, or is that basically how you proceeded?
I learned a lot from Charles, so I proceeded in many ways along the lines he did. We were able to use technology a bit more, and so hosted online forums, which, as Charles mentioned, is really important for reaching out to people who might find it difficult to get somewhere in person. And then the other thing I just add is that we were able, and I know this was true with Charles as well, really to hear from a very broad range of people. I especially reached out to different parts of the obligated sector, as well as the advocacy community, public institutions, et cetera, to get a really wide range of views.
Okay, so first, you did your review and one. So you did your review 4 years later when there were 4 or 5 standards had been enacted and they were supposed to be enforced, and that became an issue that you had to look to as well. So in a nutshell, what, Charles, first you and then Mayo, what did you hear from the community?
Well, I think the first thing that we heard from the community was that I mentioned the excitement around the presentation of the AODA, its passage, and just to underline, unanimously in the Ontario legislature. And there'd been a broad consultation process, and there was just great anticipation and expectation. And so in some ways, it's not, I think, unusual to then say that there was some concern about the speed with which everything was happening. I'm sure that when the legislation was first passed in 2005, it was thought that by the time the first reviewer, in this case me, had come on the scene, that all 5 standards would have been in place, and they weren't. And so there were some issues around that process, which we looked into and later made some recommendations. So that was a concern, I think, that came from the various disability groups, and just the feeling that they were worried about the leadership. Were the issues really getting out? And I guess one of the things we then...
The leadership from government.
Right. And just in terms of how people were being informed, the private sector, as I mentioned, had not yet come into play, and we were struck by a lack of understanding and awareness in various parts of the private sector. And so this, in part, came back then to the public education responsibility that the Accessibility Directorate had, and were they in a position to be able to do that as effectively as one might have liked.
So 5 years in, what you're hearing from the disability community is progress too slow, and from the private sector, we don't know enough about what's expected.
Right, and I think from the broader public sector, it struck me that they were better organized, that they had set up a number of vehicles to really begin to address the issues and what it meant. And then the other one, and it's been noted before, and I'll come back to it, but the municipalities, some of the municipalities were really doing some neat things, and in my view, this would kind of go back to a mayor or a couple of councillors or maybe the senior administration who just said, you know what, we're going to do something about this. So there were some good things that were happening, but there were these deeper worries about, are we ever going to get to 2025?
Okay, Mayo, 4 years later, what did you hear?
So I heard a couple of things. Some of them echo what Charles said. First of all, I just want to emphasize, and this is something that Charles and I both found, great support for the goals of the AODA and for the idea that, you know, building an inclusive society was an incredibly important objective. And again, I heard that from all sectors, including the obligated sector. So that's the positive message. And as Charles said, lots of people doing interesting things, but certainly a feeling. So by the time I was doing it, it's getting close to the halfway point to 2025, that the progress was too slow and that the system was so incredibly complex because of the rolling dates and the complexity of the different organizations. And that was chosen for a reason, but I think that there was a feeling that people really didn't know what they were supposed to do. And one of the strong messages I heard from the obligated sector in particular was, you know, we're committed, but could you please just tell us what to do in a simple, straightforward way, and we will do it. We're spending too much time trying to figure out what we're supposed to be doing.
I think one of the things in your report that struck me and a number of others as a compelling message was that you were hearing, it was common that people with disabilities would say, would you pass regulations to tell business and the public sector what to do in detail so they know what to do? But you were hearing the same message from business.
Absolutely, and from organizations, because it was, the standards are very general and very vague, and in order to figure out what exactly do they require, people were spending a lot of time, energy, and resources trying to figure out basic requirements. And my worry, in part, was that that would distract from the broader goal of pushing accessibility beyond those minimum standards.
And David, can I just build on that, because I think what Mayo said is really correct, and that was being expressed during my review. And so the key was the word that was used was harmonization. And so the concern that people were expressing across the board was, we're going to have all these standards, but how do they link together? And how do we relieve the kind of administrative pressure? Are there not ways of doing that that could make it all more effective? I think that was one of the lessons that out of our hearings, and the government took that to heart in terms of harmonization. But as we go forward, and certainly at the federal level, that's a critical issue. That how do you do it in a way that makes sure it's done, but it doesn't complicate the process of creating standards and making sure that they're defensible and enforceable.
Okay, now what I want to do for the last part of my chat with the two of you right now is to ask you each kind of a hybrid question. Both, what did you recommend to the Ontario government, you, Charles, in 2010, Mayo, you in 2014, but also what would you recommend to the federal government that they can learn from Ontario's experience? What should they build into the Federal Act to avoid to see the gains you saw, but to avoid the problems you saw? So let me put that two-part question first to Charles and then to Mayo.
Okay. Well, the first one was the harmonization piece, and as I say, we realized that the government was open to that partway through our work, and so we moved that forward. One of the things, and this speaks to the question of leadership, and we felt it was important, we recommended initially that the minister responsible for accessibility should be so identified, and even if at the time I was doing the work, it fell under the Minister of Community and Social Services, and later, of course, that's changed. But we felt that when the minister was speaking about accessibility issues, she or he should be identified as the minister responsible for accessibility. We also felt that the senior official should be at the rank of a deputy minister. And this wasn't just to create yet another deputy minister role, but there are a number of tables within government where the deputies sit, and we felt for all of them, for all of the other ministries, they needed to have that voice there.
We've seen in the United States, particularly major organizations like Apple and IBM and Microsoft have a chief accessibility officer. Ontario doesn't have anything equivalent to that at that level.
And those we just felt were critical and needed to be there. We made recommendations to change the standards development process, and I realize that for many people, that's getting into the heavy water, but it underlines that as great as legislation can be and as great as human rights codes can be, it's then how do you implement? How do you make sure that the things that you want to do, in fact, are going to happen? And we had been interested in some of the things the Americans had been doing as they approached the development of standards, and so recommended that there be one body that would take on more responsibility and have all of the standards coming within its orbit. The other thing was on the municipal side. I mentioned we'd been really impressed by some of the things we'd seen at the municipal level, but so we said you really need to continue the accessibility committees at the municipal level, but we said to the government, develop ways for municipalities to talk to one another, to share best practices. That you could find a municipality that was doing some great things, and the one right next door had actually never even talked to their counterpart or necessarily even knew it was there. We also said that the municipal advisory committees would be good ones to start talking to the local chambers of commerce because of the private sector about to move in. And that, as I noted before, there were special groups within at the post-secondary level that were really doing some good work.
Okay, I'm gonna have to interrupt because I've got to get to Mayo and get her add-ons before we're out of time on this one. I apologize.
Yeah.
I'm trying to fit 4 hours into 3 hours, and that's totally my fault, and I apologize. Mayo,
Great.
beyond what you recommended, but beyond what Charles said, what did you recommend, and what would you recommend to the federal government?
So sort of focus more on what the federal government component, just to add on to what Charles said. I think leadership is incredibly important.
And when both you and Charles talked about leadership in your reports, you were talking about leadership within the Ontario government.
Yes.
You said that both of you found that there was a lack of sufficient and effective leadership commanding the message within government and to the public.
That's right. So my first recommendation was actually renew government leadership. And I think the federal government has a great opportunity to be a champion, to lead the way. I think it's consistent with Canada's role in the world, and I would love to see that. I think that would be very powerful. I think one of the things that's very important that I learned is, make it as easy as possible to comply with accessibility. So Thea gave some great examples of very confusing, conflicting standards. Model national standards on critical issues would be a great addition to assist those that want to comply and don't have people spend all their time doing the same research over and over again. I think an effective enforcement regime that's transparent is very critical. That was certainly something I heard loud and clear. And one other thing just to mention is I think addressing the issue of building retrofits to some degree is very important. That's certainly something that I heard loud and clear in my review, and there was a great deal of confusion about it. So I would think that that's another area where looking at what the Americans have done would be really helpful and would create a great path forward for Canada.
All right, thank you very much. I'm going to come back to both of you in just a few minutes, but first I want to hear from our three other Canadian speakers. Thank you very much. Just off to my right, further beyond Charles, is Marie Butriani. Marie is now on the faculty at Ryerson University, heading the Chang School. But back in 2005, she was in a pivotal role. She was the Minister of Citizenship, responsible for developing and bringing through to our legislature the Accessibility for Ontarians with Disabilities Act. She had the misfortune of meeting me in my capacity doing advocacy from the community side, and that's how we got to know each other, often negotiating the details of legislation. It's a fantastic way that you're able to take the time to join us, and I know you can only stay for the first 90 minutes, so I'm gonna jump right in, and I want to ask you, you led this process of going out, talking to stakeholders, and talking within the government with your colleagues in the caucus, bringing a bill forward and coping with folks like us asking you to make it better and stronger and so on. And you came up with a bill that ended up being congratulated by people with disabilities and by the business community. And you passed a bill which also was voted for unanimously by liberals, conservatives, and New Democrats, and got a standing ovation the moment it passed. That's a huge, huge accomplishment. I want you to now think back to those days and offer the federal government some advice. First, what were your biggest challenges developing the law, bringing it forward, and getting it through cabinet and your caucus?
Thank you, David, and thank you for organizing this important session, this panel. Well, I thought it was very important that the bill, whatever that bill would end up being passed unanimously in the House. I also felt it very important from the very beginning that the private sector be accountable and involved, which it wasn't with the previous act. I also felt there had to be compliance measures. So again, today we take a lot of that for granted and we're still fighting for it, but we take it for granted that that's what we need. Back in that day, believe it or not, and it wasn't that long ago, 12 years ago, 13 when we started, that was not necessarily the beliefs of some other people, both in the business community and in the political community. So one of the opposition parties were very concerned about cost. The business community was also concerned about cost. So it's not rocket science. It's just talking to people. David, you were there when I had the first ever consultation between the disabled community and business. In fact, you came up to me and you said, Minister, we should do a press release. This has never happened before.
Can you describe the roundtable? Because I wanted you to paint the picture with your words of that meeting.
Well, it was, I would say about 40 to 50 people, if I remember correctly, from all big and small business, as well as people representing different disability groups, as well as government.
And there were the colleges, the universities, the transit authorities.
That's right. That's right. And then, of course, we broke into smaller groups for the rest of the process, but this was the first ever public one. It was near the airport. We had to book a big room. And what we found is that there was 95% agreement on everything. The business community just wanted to know what they needed to do, and were concerned about timelines. They said, give us time, because if we don't change as a business every 10 years, we're out of business anyway, so we'll change, but just give us the time to change, tell us what we need to do. People with disabilities were saying, we don't want to close down business, we want to access business. And then, of course, the government officials were there as well. And then there were consultations. I basically said, you were there, David, I'm not going to write the bill, you will write the bill. But I promise you, I'll do whatever I have to do to get unanimous support for it. So first you start with your own. You start with your own cabinet and your own caucus. And basically, I think it's because I've got a Greek background. Food is very important to our culture. I took every single cabinet minister out to lunch with the group of people from the disability community and the particular ministry whose standard we were talking about at the time. So whether it was transportation or health or whatever. In other words, by the time it reached the cabinet table, every single minister had this one-on-one special attention. And when you have people with the disability community and business telling a minister, all the ministers individually, we actually agree on this, it's very hard for them to go against that. And then, of course, went to each caucus. The one political party still had concerns about costs, so I showed them the American research on how much increased tax revenue was achieved because of making hotels and restaurants accessible to people with disabilities. Just that, and the billions of revenue that applied. So that satisfied most of them, and they all voted unanimously. And the other political party was very concerned about the timelines. But they ended up voting unanimously with the government on that. So I think the answer to your question in a nutshell is consult, and keep the people that are against you next to you from the very beginning. Keep them right next to you and listen to them.
We did the roundtable. We from the disability community have been pressing the government to agree to do accessibility standards, and we were worried that some from the obligated sectors would be afraid of them. But what happened at that roundtable is the various representatives of the public and private sector were saying, we'd like you to do standards. Just include us at the table when you're developing them, please.
Exactly.
Which is what you built into the law. So very much like what we heard from Mayo, a common message to government from the disability community and the obligated sector can be found as long as you get us in the room together and lead the discussion as you did. Now, you've been out of public life for a while, so you're no longer in the position where you've got to stand up and say our government does everything right and everybody else does everything wrong.
I don't think I even did it then, so.
And I know you well enough to know that you're also inherently a very humble person. I want you to look back at what you got passed in 2005. You've heard from Charles and from Mayo and from Thea about some real issues that have developed over the past 12 years. What, in retrospect, do you think you got right that you'd recommend that the federal government echo? And what, if you could go back in time and change, with the wisdom of hindsight, would you change?
I think what we got right was the consultation. I think what we got right is the review every 5 years of the legislation. What I think I got wrong was being naive, perhaps, in believing that the education component of the public would take place. I think I would have something in the law that would ensure that would happen. In my naivety, perhaps, I thought the review every 5 years would do that. It's not. I know I'm the dean of the Chang School now, and we have all sorts of contracts and workshops for business on the AODA. We have a MOOC, which is a free online course, which ordinarily those free online courses have a 7% completion rate. Well, this one has a 70% completion rate, and it's how to teach business, how to be AODA compliant with technology. So that small piece of information tells me that there's a lot of lack of information out there. And I know even going to the hairdresser, which I do once in a blue moon, and other places, when I talk about the AODA, they say, what's that? So the other thing that I think I would have done differently, and in fact, I'm sure I would have done differently, and I'm sorry I didn't do this in a better way, is talk to small business more. Because they were the only ones that were against this legislation, at least the formal body that represented small business were the only ones against this legislation. Everyone else pretty well embraced it, at least the idea of it and the hope of it, except for small business. So if I had to do it all over again, and I would advise the federal government not to forget the small business of Canada, because they are the job creators, and a lot of them are mom and pop shops that struggle. So please keep them informed and part of the development of whatever guidelines or standards the federal government is thinking of developing.
Okay, thank you very much. I'm going to now, I'm coming back to all of you with a question in a few minutes, but I want to just proceed to our second online speaker. We've just heard from Marie Butriani, who was the minister who brought in Canada's first provincial accessibility law. We've got two others in Canada, one that was passed in Manitoba in 2013 and one that was passed in Nova Scotia earlier this year. And we're very fortunate to have with us online from Ottawa, Jennifer Howard. She was the minister in the NDP government in Manitoba who led the development of the Accessibility for Manitobans Act and brought it through to its successful and also, I might add, unanimous passage in 2013 in Manitoba. By the way, the Nova Scotia Act also passed unanimously earlier this year, so that point about the importance of unanimity resonates in more than one province. Jennifer, can you hear me okay? Yeah, I can hear you. Can you hear me? Yeah, absolutely. So Jennifer is now, like Marie, is no longer in electoral politics. She's now the executive director of the Public Service Alliance of Canada, and we very much appreciate your taking the time to join us here and for our viewers watching online all around the world. So I'm going to ask you the same questions I asked Marie. First, tell me about any challenges you faced coming up with what you were going to enact in your bill and in getting it through your caucus and in dealing with stakeholders so that you could achieve the consensus you did.
Well, listening to Maria speak, there's many similarities, which tells me that we did some good things. We took the example of Ontario, and that was one of our advantages. We weren't first, we were second. So we had an opportunity to learn from Ontario, and early on in the process, I went to Ontario and met with many people, including you, David, to talk about what we had learned there. I guess for us, one of the challenges was this was not a promise that we had made in the election. It was not a concept well known in my caucus. It was really community led. The idea came from people with disabilities. They presented it to me, they pushed for it, and their support was critical to getting the bill passed. So I had a caucus in cabinet and didn't know what I was talking about. That was a big problem and was concerned. I think there was concern about would a legislative approach be effective? There was lots of support for the Human Rights Commission and education and changing building codes, but an overarching act was a big project and people were concerned if it would make a difference. There was concern from my cabinet and caucus about the cost of implementation and both the impact on the private sector, but also the cost to the public sector of having to live up to those standards. And there was an interesting concern that I wasn't really prepared for from other politicians that and the concern was kind of presented this way. Look, if we go out there and say we're going to make the whole province accessible, people are going to notice that we're not accessible. They're going to notice that, there's lots of government buildings, that there are barriers to people getting public services. And so if we say we're going to do this, people are going to say we're hypocrites and we're going to have all this negative media attention because we will be expected to be perfect. And so I took that on at every opportunity, publicly and privately, and said, we're going to embark on this journey to try to make things more accessible. It includes us, government, and includes the public sector. We are not going to be perfect. People are going to point out where we're not perfect, and we should just plan for that and prepare for that and accept that that's going to happen. And when it happens, we're going to try to deal with it and do better. But we're not holding ourselves out there to the business sector, to the public as kind of better than everybody else. We're going on this journey together. So those were the major kinds of barriers to getting it done.
That you make about the role of government is especially important because it's resonated here in Ontario, where the approach to developing access standards has always been government's got to go first and government's got to lead by example. And there are times when government leads by a good example, but there are times when government leads by a bad example. But more importantly, all those barriers need to get fixed, and there's no reason why we should be telling the private sector and municipalities, you can just sit back and cool your heels till the largest organization with some of the biggest barriers to fix till it's all done. In fact, in some areas, small organizations can move much more quickly, such as fixing your websites. It's much easier to fix a website that's got accessibility problems if it's a small organization with a small website. If it's the entire provincial government, that's a much longer task. We sure don't want to tell those small organizations, you don't have to do anything till the government takes the many years it takes. So what you learned in terms of anticipating is a message that we could benefit from elsewhere as well. Let me ask you the same question I asked. Actually, before I jump into, can you tell us, because you had the advantage of coming after Ontario, you came down here, you talked to me, you talked to the folks implementing the legislation. When you went back to Winnipeg to sit down and work on your law, what message did you learn from Ontario, what they got right, what they got wrong, what you would do, and what did you decide you would do differently?
Well, I think one of the things that we felt that Ontario got right that we replicated was when it came time to do standards, we started with customer service. We started with it because a lot of the work had been done in Ontario. We could use that, but also because I felt that focusing on that was going to have the broadest reach in terms of education, that we were going to reach the most people by giving industry an obligation to make sure that their employees were educated, knew how to serve people with disabilities. That would have ripple effects in those employees' personal and private lives, and I think also help deal with stigma around disability. So that was something that we did. I think one of the concerns I had coming from Ontario was the cumbersome compliance structure. That was something that we did not want to replicate. We didn't feel like it was going to work as well for a smaller province like Manitoba. We just simply didn't have the infrastructure inside government to have that kind of compliance structure. I knew that I was not going to get another 20, 30 staff to hire to do the compliance. But that being said, and I might be anticipating your next question, we never really did figure out compliance. And at some point, there was a decision I had to make that, were we going to wait to introduce the bill until we had everything figured out about how we were going to enforce it, 5 or 6 or 7 years down the line when all the regulations were developed, or were we just going to introduce the bill and figure out compliance as we went? And I made that choice to introduce the bill. But I was never satisfied that we had figured out how we were going to enforce it. We had lots of different ideas, and hopefully, there's been a change in government. I hope that they will continue to look at how to enforce it, but we never really satisfactorily figured that out.
Concerns you heard from the Human Rights Commission side?
Yeah, we had all. And because I think we had very strong activists who were involved with the Human Rights Commission, and all throughout there was this underlying concern that somehow this act would take away from the role and power of the Human Rights Commission. And I think in some other provincial jurisdictions, some of that, and federally, some of that had started to happen, where human rights commissions were seeing their role and authority diluted. So we were very clear, and I think it's even in the act, to say to the commission, of course, there is always going to be a role for complaints-based mechanisms. There's always going to be a role, but when over half your complaints are related to disability and accessibility, that tells me that we're not doing the job before we get to the complaint to make sure that things are accessible. And one of the arguments that we used with the private sector, and we also took the approach of bringing the private sector and industry and those who would be affected by the regulations together with people with disabilities to talk together about how to do this. But one of the arguments I used with them is, look, industry, businesses, you don't want to have to make yourselves accessible in response to a complaint, in response to a human rights complaint that could bring you negative publicity, that is going to be a confrontational experience as much as they try to mediate. You don't want to wait for that to happen. You have an obligation now to be accessible. Why not let us help you plan and figure out how to do that?
You anticipated part of this, but looking back, as I asked Marie, looking back on what you accomplished, and you've now moved on to other things, so you can criticize yourself, your government, or compliment you folks from what you've learned. With hindsight, what did you get right, and what do you wish you would have gotten better, or would you recommend the federal government do differently from what you did?
I think we got right is I think that we produced legislation that is durable. Remains to be seen. The change in government is new in Manitoba, but it was unanimously passed. There was a strong community coalition that reached out to politicians of all stripes. And so I don't think this is a bill that future government is going to come in and undo. There will have to be vigilance to make sure that they continue developing regulations and develop compliance, but I think it is durable. And I think that's because we took time, we did a lot of consultation, we built public support, and we critically built the support of the private sector. So that I think we got right. And we just kept moving forward. Every time there was like another kind of barrier put in the way, like this bill, we went over a whole election cycle, and we did something before the election. We brought in a little piece of legislation to commit whoever won that election to do something after the election. But we just kept taking the next move, moving forward, despite every barriers. What we got wrong, I think we didn't put enough resources behind the legislation, and we were bringing in the legislation at a time when all governments were trying to restrain their budgets. I've never lived through a time when governments aren't trying to restrain their budgets, so I don't know what that looks like when times are great, but I think we needed more resources. We had a small, great team in the Disability Issues Office, but I think that one of the concerns about taking that approach of having one place in government deal with this was that kind of let the rest of the government departments off the hook. And we didn't really use the full power and strength of government to say, you know, it's not only the minister responsible for people with disabilities who's responsible for this act, it's the whole government, it's every minister and department and deputy minister. And I think with some more resources, we probably would have been able to do more of that work within the government and within the public sector to make sure that there were people who were championing the bill and the idea of accessibility and were doing the work to make those regulations live and be real for people.
Jennifer, and stay tuned. I'm coming back to you in just a couple of minutes. But first, I want to just turn now to our next speaker and our final from the Canadian contingent, and that's Val Piche. Val comes to us. She's now a senior official at the Toronto Dominion Bank, but back from 2006 to 2011, she was the chief of staff to the Minister for Community and Social Services in Ontario, the Honourable Madeleine Meilleur. And at that time, that large ministry had responsibility for implementing the Accessibility for Ontarians with Disabilities Act. So Val comes in as chief of staff and the political staff, overseeing, working for the ministry who has to oversee what was the development of the first 5 major accessibility standards. The customer service standard was passed in 2007, and in 2011, a second standard was passed which covered employment, information, communications, and transportation. All of that went on while Val had the good fortune of being in of steering the minister's office, and we had the good fortune of her being there as well. So Val, I want to talk to you about what you learned over this time and what the federal government can learn from you about the experience of developing these accessibility standards. What kind of challenges or problems did you face either within government or from the private sector or from the municipal sector or even from the center of the government, the Premier's office, when you were trying to, and of course from folks like us from the disability community, when you were trying to get these standards enacted and on the books?
Yeah, thank you, David. And it's good to be back. I'm obviously reconnecting with a lot of people that I've worked with in the past on this legislation. And I do complete my customer service mandatory training at TD twice a year. And so it's very odd to be in a position to complete the actual training that you help create, but at the same time, really exciting. And I am one of those people now.
You did it on time, right?
I did ahead of time, actually. I did it ahead of time. But also, I'm now someone who now truly notices accessibility around me wherever I go. So I think a few things. The one thing it taught me was patience. But there were 2 quotes that I heard this morning that really rang true. And one of them was, everything has been a negotiation. So Thea, talking about how it's not just a done deal, it's all a negotiation. But I think at the same time, am I very loud? I have a very loud voice. Okay. The other piece is, from you, David, where it doesn't go far enough. So now you need to try to mix and marry. I think the willingness, and everyone has the willingness around the table, it's how it's done. And we've heard this several times around the timing. Some people want to go quite quickly while others want to look at it slowly. The one, a big challenge that we have in terms of the political landscape, we were also going into an election. And so in 2011. So when we were nearing the end of all of this, it was also all of these different cabinet ministers managing different relationships with the sector that they were overseeing and trying to manage the demands and the requests from that sector, along with the need for us to finalize these standards.
And those, you're talking about requests that had nothing to do with the AODA.
Correct. So anything that they might be, so when you look at the transportation sector, and we might have been talking about large infrastructure projects and the costs around that, they would typically not necessarily come to the table with those with accessibility in mind or built in. And so they kept seeing it as an add-on. And we typically pushed back to say, just incorporate within what you're asking. And so there was a lot of back and forth on that. It was never fully integrated. And I think one of the reasons for that is that it was only our minister that had it in her mandate letter to push forward.
What the mandate letter is.
So every minister, both at federal and provincial levels, typically get mandate letters from their leader. So the prime minister or the premier will write a mandate letter to every minister, and pretty much that's their roadmap on what they need to focus on for their mandate as a cabinet minister. And so, and those letters, especially in recent years, are now all public. And so these are easy to look up. What we faced was that our minister at the time that was overseeing the legislation had specific language around developing and implementing the standards.
In fact, it was a big priority set by the premier for her.
Exactly. And so when you see that, those are your marching orders. This is what you focus on. And there's different things in those letters. It's not one issue letters. You probably have 4 or 5 top things that you really got to look at and really got to focus on. And for us, the AODA and the standards were at the top of that list. They were not, however, at the top of the list of other cabinet ministers that were impacted by this.
So a minister of transportation didn't have transportation accessibility in their mandate letter.
Correct. And so, or not as explicitly as it was, our minister had wording that said, you will work with your counterparts and other ministers in government to enact these standards. That wasn't necessarily reflected in their mandate letter. So if I had a piece of advice for the federal government that's looking to do this is it has to come from the top of the house. And we've heard every leader be quite supportive around accessibility. So it goes beyond that. It goes in terms of actually talking to, and I would say the Secretary of Cabinet or, it has to be on both sides. It has to be on the political side and it has to be on the civil service side.
So your recommendation is that in the Prime Minister's mandate letters to each minister, there has to be concrete specific directions on implementing accessibility, not just the minister responsible for implementing the law, the new national accessibility law.
I would add it in the wording. And so it doesn't need to be their top priority, but if you're going to have, if the decision is that you have one minister that is coordinating all of this, then at least reflect some of the language in the other ministries that will have that impact. And so that at least gives you something to point to say, not only do I have this as a mandate, it's a shared mandate between the two of us. And I would do something at the civil service level as well for deputy ministers.
Performance contrast with the deputy minister.
Performance is a strong word. So I see performance that's sometimes linked to compensation and I think it's here's what your priorities are. We all look to our supervisors or bosses to give us some type of direction on the type of goals and end results that they want to see at the end of the day. There should at least be wording in that sense for all those ministers so that it allows that one minister who has key responsibilities to be able to go to their colleagues and they have something to point to be able to get that done.
Okay, thank you very much. This is great. Now, I'm advised that Minister Qualtrough has joined us. And before I call you up to say a few words of greeting, I just want to, I've held one question back and now it's my chance. We know you're going to watch the whole video, but this is a chance to where you get it live the first time around. I've got a question I'm going to ask each of our speakers. And I'm going to ask them in the order in which you each spoke, starting with Charles, and then Mayo, then Marie, then Jennifer, and then finally Val. One idea to address one of the concerns that you each talked about that a number of us have put forward to the federal government, and we know they are considering now, is the idea that the National Accessibility Law should create a new office, office and officer, someone to be called the Canada Accessibility Commissioner. They would report to Parliament, not to the government. They would be independent of government. And they could have 3 responsibilities, more. But the 3 would be these. First, to be Canada's champion on accessibility, to be the voice, the outspoken, if you will, auditor, rapporteur, let us know how we're doing, the voice to champion the cause. Second, building on what Charles and Mayo recommended, to lead the development of accessibility standards. They still would have to be enacted by cabinet, of course, but to make the development of those standards under one roof, but independent of government. And finally, to be the place that would lead the enforcement of the legislation. Because again, you can't enforce against yourself and do it in a fair, be expected to do it in a fair way. So I want to ask each of you what you think of that idea. First, Charles and Mayo, from the point of view of your independent reviews, and then our next three speakers from their experience years ago developing legislation or standards. So Charles, first, what do you think of the idea?
Well, I think it's a really solid idea. Sound on. I think it's a solid idea. The way I would see this, and I think it goes back to the work that we've been doing in this province, the former Lieutenant Governor David Onley, who had taken on accessibility as his sort of key thing that he wanted to help further, often said that, you know, we can have legislation, we can have human rights codes and so on and so forth, but we're really talking about a cultural change here, an attitudinal change. And so one of the things that we need to do to really make sure that we go farther. And as I've looked at some of the discussion at the federal level, it seems to me that here, you know, we created the official languages commissioner position, and with certain kind of key responsibilities for a reason, that it was to really hold the government accountable. We have human rights commissions now across the country and at the national level. And I think that in doing something like this, it would really put a finger on how serious we take the issue of accessibility. I think there are undoubtedly questions around the nature of how that position would function, but I do think that we know from Ontario's experience, and I think what was said about Manitoba, that, you know, every couple of years, there are other issues that come forward. And so one year, you know, it may be that accessibility, if you like, is the flavor of the day. Another year, it's environment. Another year. And so how do you keep that going? How do you keep the drive behind it? And every government is going to find that the disability community at some point, some people are going to get up and say, you're not going fast enough, you know, we need to do more. So I would support this idea. I think it could really help in terms of a lot of the things that the federal government needs to do. But most importantly, there would be somebody who would be and be seen to be leading that broader discussion across the country.
Okay, thank you, Mayo.
Again, just to agree with Charles, I think that accessibility touches everything. It touches what everyone in government does. And one of the challenges you see is trying to find a more integrative space for that. So I think that the idea of having a central figure is very, very important. And as Charles said, a champion for accessibility is, enforcement is important, but having a champion is so incredibly important. And I would say that's even more important than enforcement, because it is that cultural change that I think we all need. So I really support that. And then the harmonization point, again, just trying to figure out how to make it easy to create an inclusive society is a function that I think could be brought together in a way to be much more efficient and effective than different ministries all trying on their own to figure out what one ought to do here or there.
Okay, thank you. Marie, you have the advantage of looking back from 12 years afterwards. If you could reach back in time, would this something that you think would have been good for Ontario, and is it something you'd recommend for Canada?
I would, but I would stress, I guess what Mayo was saying, there has to be a champion and an education component that's very strong.
Right.
Otherwise, it's completely unfair to have a compliance agent if people don't really know what they need to do.
Of course, it's all together. Jennifer, you just turn your microphone on. You told us that one of your regrets with the Provincial Act was including enforce the exact compliance regime, but you were struggling with getting it through Parliament, through the legislature, and so you had to make tough decisions. With hindsight, is this something you would recommend to Manitoba, or is this something you would recommend to the federal government to consider?
Yes, I think it is a a really interesting approach with a lot of promise. I would say that you would have to, I would recommend you include in the role also the responsibility to develop other champions, to develop them throughout government, throughout industry, to work with them. That is something we did do, I think, correctly, is we had people assigned in each department to be doing this work and provided them training and network to talk about how that was going. And because I think we want to integrate accessibility, not have only one person responsible for it. And the other thing I would say is with a commissioner, is you also want to give them a responsibility to connect people with disabilities with the private and public sector that affect our lives and keep those conversations. That was the richest, best thing we did, was in some ways force those folks into a room together to have the tough conversations about how to make the world more accessible.
Okay, thank you very much. And finally, before we go to Minister Qualtrough, Val, from your experience being at the front lines in a minister's office trying to get actual accessibility standards passed, would this have been a helpful process? Is this something you would recommend to the federal government?
I think so. I think there's a couple of pieces that I might shift a little bit. I'm not sure that a commissioner should be the one to develop the standards per se. I think the ownership needs to stay with those ministries that oversee. I wouldn't have necessarily had one minister that was responsible for developing every standard. I might have aligned that with those whose ministry it directly impacts, with the obligation of connecting with the other ministries, that there would be obvious ripple effects and that would bring in those other ministries. But to have a commissioner, to Marie's point around education, to be a convener, like Jennifer's point, to bring the private sector and the community together. Make sure there's the same number of people, though. We definitely saw in the standard development committees that when the private sector went and sent a whole slew of people, they outvoiced those from the disability community. So you really need to make sure that there's parity at the table, and that they feel like, and that everyone around that table feels like it has a voice, not just necessarily it being the loudest. But the commissioner itself, I could see it holding the government's feet to the fire. So we all pay attention when there's a report that comes out from an independent commissioner to government, and it really helps to drive that agenda forward. So I think that itself has a positive influence. I'm not sure I would just give all of the legwork to that commissioner. I think the government needs to have some ownership over that as well.
Right. Okay. Well, thank you very much. And now, with that, Minister, we've just completed our chat with Canadians, the Canadian perspective, and I just want to invite you to just have a moment to bring words of welcome. We are delighted you're able to be here. And I want you to know that as we are talking, we've now heard from the Canadian experience. After, we're going to move to the American and then Israeli experiences, both of which may respond to some of the areas that Val was just talking about, as well as others. But I want you to know, Minister, that because this is being streamed and will be archived online, this is going to be a resource not only for you, who we're aiming to serve, you and your government, but this discussion this morning can assist those 7 provinces that have not yet developed an accessibility law. We hope they all will. But also other countries around the world which are considering whether or how to do this. So we're hoping that the ideas we're bringing together will be helpful to you over the next weeks and months, but will also help others across Canada and around the world. So welcome, and thanks so much for joining us.
Thank you, David, and thank you. I apologize. I had a cabinet committee meeting that took me away for the first hour, so I'm here. Thrilled to be here. Been looking forward with anticipation to these discussions. I guess how I would frame my current thinking, David, on this is I actually think there's some pretty broad consensus, on the functions, on the kinds of things functionally we want to achieve through this law and through whatever governance model results in this law. So it's education, public awareness, compliance, enforcement, standard development. I know I've missed a few, but I mean, I don't think we're terribly in opposition on the kinds of things we want this to do. I think the how is really what I'm keen to hear about, and even this little snippet I heard since I've been here I'm really keen to explore a little bit, because functionally, if we look at the model, and the two that Charles talked about was official languages or say Canadian Human Rights Commission model. Those are two different types of commissions, right? An official language commissioner type, whether it's an ethics commissioner, an official language, independent of government, reports directly to Parliament, but historically focuses really on the workings of government, isn't necessarily tasked or tied to the private sector. In the same way. So there's limits on that kind of model. It doesn't, the message it sends to stakeholders is extremely clear though, and we can never undervalue how important that message is around the importance that any given government puts on this area. But kind of practically and functionally, there are some limits to that model. And we've looked at all of the, we have a lot of them in Canada, these agents of Parliament, commissioners who report to Parliament directly. The relationship with departments is different. Or if you look at more of a Canadian Human Rights Commission model that can dive more directly into the private sector in areas of federal jurisdiction. I mean, do we want a governance model? That commission, though, reports to a minister. Quasi-constitutional status, so it's not a small feat, but those are two very different approaches, and those are different models in terms of where we put these functions. Do we put public education in a government department? Do we put it in an advisory body? Do we put it in a reporting commissioner, whether it's an agent of Parliament commissioner or a commission-like structure like the Canadian Human Rights Commission? Is it within the Human Rights Commission? I mean, all these models are up in my brain. As I know they've been in yours for decades, David, but it's really, this is the kind of input I desperately need right now because the pen is hitting the paper as we speak. I'm keen to have the kind of functions discussion, but I think we're almost there in agreement. I'm really keen on kind of practical advice on the governance model. Who's going to deliver these functions? If we want to include the private sector and we make it an agent of Parliament, is that limiting? And who else then is targeted to kind of work with the private sector? Is that government? Is it a separate advisory board? So rest assured that I'm listening. I'm not going to talk hardly at all after this. So just thank you. I'm here for the next 2 hours and I'm super keen to have your insight and very granular insight like that feedback because we're like literally writing this law right now.
All right, well.
No pressure.
No pressure on you or us. That's the way we like it. Listen, thanks so much. And I know Marie Butriani has to leave. And by the way, we are going to go straight through till 1 o'clock. So anyone either around the table, if they need a health break, just go ahead. I'm going to forge ahead because our next speakers are all going to be sharing with us over the web hookups. So now we get to turn our attention to the United States. The U.S. Led the world with the passage of the Americans with Disabilities Act and has inspired legislation elsewhere and movements elsewhere. That's not to say they got everything right. They just got everything first. They've also made significant steps in moving forward to make their society more accessible for people with disabilities. And indeed, we are in no small measure playing catch up. So we have 3 speakers who will be joining us online. And I'd like to turn to the first of them. David, please unmute your mic. These are all fantastic speakers, as have been all our speakers up to now. I'd like to introduce everyone to Mr. David Capozzi. He is the Executive Director of the U.S. Access Board. He'll tell you more about what they do, but they're at the center of developing recommendations for accessibility regulations and standards in the United States. So David comes to us from the Washington, D.C. area. David, welcome, and thank you for taking the time for joining us.
Thank you for having me, David.
So David, can you, all this David stuff's going to get confusing, so my solution is we're going to change everybody else's name to David at this table. I stole that from Monty Python, by the way. First, can you just tell us what the Access Board is, how long you've been there, and how accessibility standards are developed in the United States? What's the process?
Sure, thank you. And good to see you again, Minister Crawford. The Access Board is an independent federal agency. We were created in 1973, and we're the only agency whose primary mission is accessibility for people with disabilities. We write accessibility requirements under several laws, the oldest being the Architectural Barriers Act that applies to federal buildings, under the Americans with Disabilities Act for buildings and facilities and transportation vehicles, for communications and information technology under the Telecom Act, and under Section 508 of the Rehabilitation Act. We write standards for medical diagnostic equipment. We provide training and technical assistance on all the work that we do, which I think is a very important component. And we enforce the Architectural Barriers Act. So in terms of how rulemaking is done in the United States, it's governed by an old law called the Administrative Procedures Act. And that outlines the process that agencies have to follow when writing regulations. And there's two types of rulemaking. One is called formal, and the other is informal. Formal rulemaking is rare. It involves hearings and presenting information before a commission or a judge. Informal rulemaking, or what we call notice and comment rulemaking, is really the most common process used by agencies for writing regulations. And the way it works is agencies first propose a rule or standard and invite the public to comment through a notice of proposed rulemaking. In some cases, agencies will, before that, will do an advance notice of proposed rulemaking before the proposed rule. Agencies have to provide the public with notice of its intended actions by publishing the proposed rule in this document called the Federal Register. It's all online now. The notice provides a period for public comment that can range from a minimum of 30 days to an unlimited amount of time, 120 days or more, depending on the complexity and the interest in the rule. And then comments are generally submitted online through a portal called regulations.gov. Our agency also holds public hearings during the comment period, but those are not required. And then after the comment period closes, the agency reviews the comments and publishes a final rule. The final rule has to be based on the rulemaking record. Otherwise, the agency could be sued and the regulation overturned for being what's called arbitrary and capricious. There's an executive order that governs rulemaking as well that was established in 1993 and has been updated since. Agencies have to prepare what's called a regulatory analysis, including an assessment of alternative regulatory approaches and a cost-benefit analysis on rules that are economically significant, meaning $100 million or more per year, and then significant rules, those that raise novel legal issues, and economically significant rules, those that cost $100 million or more, have to be reviewed by the Office of Management and Budget, which is an agency of the White House. Once OMB completes its review, the agency may then publish the rule in the Federal Register for public comment, and then the process is repeated for a final rule. The time to complete a rulemaking really depends on a number of factors. OMB has 90 days for its initial review. Agencies have to provide a minimum of 30 days for public comment, and OMB has another 90 days to clear the final rule. It's a total of 7 months. OMB can take less time, and as John knows, sometimes OMB can take a lot more time, although they're kind of governed by this 90-day goal of completing its review. The shortest time we've taken from a proposed rule to a final rule was 6 months, which we did 4 times, 3 before the executive order was established, and then once thereafter. The executive order makes it a little bit harder to complete rules in that short of a time. On the average, for the 14 rules we've finalized, it's taken us 20 months from publication of a proposed rule to publication of a final rule. When we add an advance notice of proposed rulemaking to the process, that added on average 3 years before the issuance of proposed rule. The shortest time was 5 months. When we've added an advisory committee, and that's a body of experts that give us advice and recommendations on what a proposed rule should contained, which I strongly advise that you use, it added an average of 5 years before issuance of proposed rule. The shortest time was 1 year, which we did twice. So it's possible to include that important public participation before proposed rule without adding a lot of time.
Standards or regulations the Access Board does, are you using an advisory committee in each case? And why 5 years?
Yeah, so we have used 14 different advisory committees involving over 350 different organizations since I've been with the board. We don't always use advisory committees. I always ask 2 questions before we initiate rulemaking. Do we have enough information to proceed directly to a proposed rule, and is there enough support? And if the answer to either of those questions is no, then we might choose to either use an advisory committee to both gather that information and build the support, or we might use an advance notice of proposed rulemaking to get information, or we might hold some information meetings to gather information. But in either case, we find that using advisory committees certainly builds support for the rule. The people that were on the advisory committee become ambassadors for whatever the issue was. And I strongly believe in the process. I think it makes the agency smarter when it issues its first proposed rule, because the difference between a proposed rule and a final rule will be very small. So it's really important that you get the proposed rule right from the beginning. And if you don't have the public participation before you put pen to paper, then things become set in stone. And why it takes time, I mean, sometimes we're doing 2 or 3 rules at a time. We're a small agency. We have 28 staff, a budget of under $8 million. And then when you add in the requirements of the OMB review process and the time and expense of developing cost-benefit analysis, it adds time.
Who has the final say? Sorry, somebody's tearing some tape in the room. I'm just going to ask if you could do that somewhere else if possible. What I wanted to ask you is, who has the final say? Who's the official who finally approves the regulation? Is it the White House? Is it the president? Is it a cabinet secretary?
So sometimes it depends. I'll give you an example. Under the Americans with Disabilities Act, when we issue a final rule, it is a guideline. It's not enforceable until it's adopted by the Department of Justice and the Department of Transportation. Once those 2 agencies adopt our guidelines as an enforceable standard, it then becomes law. The president doesn't have to play a role. Congress doesn't have to play a role because they gave us the authority to write the regulations. So, and that would be a recommendation that if I could change the way the law was structured, I would eliminate that second step of the process and instead have one agency develop the standards, the second part of the process, adopting them as enforceable, adopting the guidelines as enforceable standards, I think doesn't add much to the process. In our case, Department of Justice and Transportation are both members of our board, so they've had a say in the development of the proposed rule and the final rule. And so when they adopt our guidelines as enforceable standards, the differences are small enough that you can put on one piece of paper. In some cases, there are no differences, and they're just adopting them as an enforceable standard. So I don't know that second step adds much to the process.
That really helps, David. I want to focus you for a minute on the issue of cost benefit. You said that there's a requirement that there be a cost benefit study. You've been involved in doing those. And at one level, intuitively, it makes sense. But tell me if it's been a useful exercise and what recommendations, if any, you'd make to on whether that's something we should be requiring in our legislation.
Okay. Well, first of all, doing a cost-benefit analysis is expensive and it's time-consuming. For our agency, and this is not true for all agencies, some of them spend more time and money than we do, but we're a small agency. We spend about $150,000 on proposed and final regulatory assessments for one rule. And they can take as long as the drafting of the rule, and they need to be done in tandem so that they can, the cost-benefit analysis can inform the proposed rule and inform the final rule. We've done 22 proposed rules and 19 final rules since passage of the ADA in 1990. I can only think of a few occasions where the regulatory assessment has made us change a policy direction. And one example is we limited the application of our outdoor rulemaking for trails, campgrounds, picnic areas, and beach access routes to only federal facilities because the cost was so high and it was too high to apply the rule everywhere else. So the private sector and state and local governments don't have those standards that apply to the great outdoors, only the federal government. And that's one example of where the reg assessment really did inform the direction that we took in the final rule. But like I said, we've done 22 proposed and 19 final rules, and maybe there's one other occasion where we've made changes based on the regulatory assessment. It's a process you have to go through in order to get your rule cleared by OMB. It's certainly not a process that everybody enjoys. The other thing is, it's we use contractors to develop the cost-benefit analysis, and we regularly have to redo the work of the contractors because there are very few who do regulatory assessments, and even fewer with knowledge of accessibility requirements. So it's kind of a cottage industry, and we wind up having to do a lot of that ourselves after the contractor has taken a stab at it.
With that, what challenges, if any, have you encountered trying to quantify the benefits? The cost side I get, but the benefits.
Yeah, we try very hard not to quantify the benefits. It's very hard to quantify the benefits of civil rights, and so we don't generally take a stab at that. And OMB typically allows us to do that, but in other agencies don't get such a pass. And John, I think, can talk about that because they had to DOJ had to quantify benefits for some of its rulemaking. But quantifying benefits is very difficult. You have to sometimes use a proxy for analyzing the benefit. Analyzing the cost is a little simpler. What we do is we analyze the impact of the incremental cost that the regulation is adding to the national economy, and then we multiply it out. So let's say if you're setting regulations for drinking fountains, you look at what the change is from standard practice, and whatever that cost is, then you multiply that times how many drinking fountains you think are going to be installed that year. And then that gives you a unit cost for that. And then you add that to doors and ramps and parking spaces, and then you add all of that up and you come to a dollar amount, and then you try to offset that versus the benefits. And like I said, we try to just qualitatively describe the benefits and quantify the cost.
David, one other area I'd like to just briefly touch on with you is that one of the areas that the Access Board does is set standards for Section 508. And just to explain to our audience, Section 508 of the Rehabilitation Act imposes some requirements on accessibility of technology that the federal government buys. It's a procurement restriction or requirement. And so the Access Board can set standards on for ensuring the accessibility of what they buy. In Ontario, under our access regulations, they simply say to consider accessibility when you're procuring goods and services, but don't say what that means or what to look for. Can you tell us any lessons Canada can learn from your experience setting procurement, setting requirements or proposing standards under Section 508?
Well, first, let me just give you a 30-second overview of what Section 508 requires. It applies only to the federal government. So whenever the federal government develops, uses, maintains, or procures information technology, be that a website or a computer or software, copier machines, then that technology has to comply with standards that we issue. One of the lessons that I think we learned is that the way the law works is the enforcement is each federal agency is responsible for enforcing against themselves. So if a person has a complaint about an inaccessible website at the Department of Transportation, they file a complaint with the Department of Transportation. It's kind of the fox guarding the chicken house. Our agency was actually created in 1973 because of a failure of that same structure for the Architectural Barriers Act. The way the Architectural Barriers Act used to work was each federal agency was responsible for enforcing against themselves. And a study was done in the early 1970s by the General Accountability Office that showed that it didn't work so well with self-monitoring. And Congress called for the creation of an independent central agency to enforce the Architectural Barriers Act. And that was how our agency was created. So I think that would be one thing that I would recommend is not have self-monitoring or each agency responsible for enforcing against themselves. The other is that what we learned, we've done our standards twice now under Section 508. First time we did, this might be getting a little into the weeds, we wrote the standards based on a product type. So we had provisions for telephones, provisions for websites, provisions for software. And that was before the days when we had multifunction, machines. That was when a phone was a phone. Now a phone is not a phone, it's a computer and it's everything else. And so now we've changed our approach and our most updated standards that we issued earlier this year to a more functional approach. So we look at the function of what it is that the technology does rather than what type of product it is. And I think that will make the standards last a lot longer.
All right, thank you very much, David. I'm going to move on, and we really appreciate your taking the time to take part. David has talked about the process of developing access standards in the United States. I want to now move to the process of enforcement of the Americans with Disabilities Act. And we're joined over the web with Mr. John Wodach. John, are you there? And can you unmic your microphone, please? You with us? Please tell me yes. Okay, do we have John? Okay, we are having a problem here with, I'm just going to ask if Jess can see if you can contact him and see if you can get him on. Oh, well, you gotcha.
Yes.
Hey, John. Thank you for joining us. John was from 1990 to 2011 the director of the Office of Disability Rights in the U.S. Department of Justice. And he'll tell us more of what they did, but he was on the front lines of enforcement of the Americans with Disabilities Act from right after it was enacted. John is now on vacation as we speak, somewhere in Spain, and we appreciate your taking the time to connect up with us. And if you could email us some sangria, we'd be really happy, especially for 11 in the morning here. So John, please tell us what the Office of Disability Rights does in the Department of Justice. You had 150 employees. Tell us how you enforce the Americans with Disabilities Act.
Well, thank you, David, and I've enjoyed listening, and I feel I've gotten a tutorial on the experience of people with disabilities in Canada over this time. I've enjoyed it immensely. The office that I headed up was created to implement the Department of Justice's responsibilities under the Americans with Disabilities Act. You can think of that in terms of enforcement, but it was a much broader role that the department faced. So the main obligation we had in terms of enforcement was to ensure that the law was being complied with by entities in the United States. And so we had the ability to go out and investigate and bring lawsuits if we couldn't bring about voluntary compliance. We also received thousands of complaints from people with disabilities, which we then used as the basis to bring about systemic change through either investigations and voluntary compliance agreements or through lawsuits and then results from that. But there were other parts of the office that were as important. An important feature of the Americans with Disabilities Act was the requirement that the agencies that had responsibilities to enforce had responsibilities to provide what the law called technical assistance, which is information to people with disabilities, information to entities that are covered by the law, information to the general public, so that they would understand what the law meant, understand why the law was there, understand why a ramp had to be a certain size. Half of our staff was involved with this public outreach and technical assistance. We also had lawyers that worked with David's office, with the U.S. Access Board, on the development of standards. We had architects, we had professional investigators, we had persons who operated our website to provide public information, persons who developed information so that people could understand what the law was about. All of those aspects were significant in bringing about change, because what the ADA really was a change in the way that America does business. If I can
carry on.
If I can go back to, I think one thing I'd like to say, since we've been listening to David Capozzi and the importance of the Access Board, I would recommend to you two things from what I've just said. One is to have a body like David's, whether it's a governmental body or it's an independent governmental body, but a body that is there to develop standards for what are accessible facilities, what are accessible outdoor areas, what are accessible websites. I think having that group of people come together with their expertise to have a comprehensive approach is one of the important things that made the ADA work. I also think that the requirement for education and outreach cannot be more important. The day after, I'll just tell you a story. The day after the ADA was enacted, our office got a call from a hotel in North Carolina, one of our states. And the owner of the hotel, it was a small business, said, "What did you people in Washington do?" And we said, "What are you talking about?" He said, "Well, a wheelchair user came to my hotel last night and said there was a new law that entitled them to the best room at the cheapest rate." He said, "What did you do?" He said, "Well, I gave him the best room at the cheapest rate." He said, "Well, it pointed out the need for educating businesses as well as educating people with disabilities as to what their rights are." And I think having that be an important part of your law is very significant. Another thing that was done at the time our law was passed, the Congress created an independent group, which we now call the ADA National Network. There are 10 centers around the country that are work with the government, but are really independent of the government, and they provide really up-to-date information on how to comply, what the law means to entities in their area. And it has been they have played a significant role in having people understand what the law requires. A lot of people don't want to go to the federal government to find out what the law requires because they're going to admit that they are in non-compliance. But if there is a body of people who provide accurate, consistent information about what the law requires, as well as what works, what another agency has done, another hotel did to make itself compliant, it's a very useful public outreach service.
Now, could you talk to us now about the use of strategic enforcement strategies by your lawyers and your staff? And just so everybody understands, these are lawyers who work within the Department of Justice. It's not private lawyers.
That's correct. And a number of the lawyers in this office were involved in the development of the law, so they were pretty knowledgeable about the law, and were involved with the Access Board in developing the standards, so they were knowledgeable about what the law required. But I think we had to have a strategic approach because this was a brand new concept for our country. And one of the things, so we had a strategy. We wanted to have a nationwide presence. We wanted to be in urban and rural areas. We wanted to be all across the United States. We wanted to deal with all types of disabilities, not just, people tended to think of the ADA as something that changed the physical environment. It was much broader than that. We're talking about people with seizure disorders, discrimination against people who had HIV disease, people with intellectual disabilities and the difficulties they had working with police departments, accessibility of the court system. So part of the idea was having a nationwide presence. The other idea was focusing on key issues that were important to people with disabilities as they went about their daily lives. So some of the key issues, a 911 system wasn't really working for people who are deaf or hard of hearing. People who were blind had difficulty with the standardized tests that were the gateway to our colleges and universities. Our court systems were not really providing accessible features, especially accessible jury boxes. People who were wheelchair users, people who were blind, were being denied jury service. So we looked at important issues like that and tried to focus on them so that the American people would understand this law was dealing with important issues for people with disabilities so they could participate in everyday American life. We also looked at it as having some symbolic cases. Cases or matters that would show what the law was about. One of our first cases was making the Empire State Building accessible. The Empire State Building's a key, it's a symbol of the United States, and it is a tourist attraction, and many people go there. It wasn't really fully accessible. Making it accessible drew public attention to the law. At about the same time that we had the law passed, the Olympics were coming to the United States, ensuring that the Olympic experience was accessible so that there were accessible seating in all of the venues, that the venues were also accessible for participants with disabilities. So if you were having a dugout in a baseball field, the dugout would have to be accessible. No longer could you just have a dugout that had stairs going from onto the playing surface, because you would keep people with disabilities from being able to participate in sports. I mean, ticketing and how you provided ticketing, there were a number of issues that were very much in the public eye. One thing that we developed as a result of that, together with people from the Access Board, was what we now call line of sight over standing spectators. So the stadiums for the Olympics were the first stadiums in the United States that provided a line of sight to the playing field when everyone stood up for wheelchair users. It just affected how you designed the facility. And so we did that in agreements with several of the facilities. Then we developed technical assistance documents that we provided to the architects in the United States, to the sports groups in the United States, so that future designs would include those ideas. I think you had a combination. Part of our goal at the beginning was also to reach out to people with disabilities and find out what the issues of importance were to them, so that we put our resources, which were substantial, but certainly not enough to deal with everything in the United States. So we were dealing with issues that were important to them, that you know, the first things they wanted done were things that the federal government was addressing in terms of its strategies.
Enormously helpful. Could you just take a moment to tell us, from your perspective, about the importance of, or the value served by public enforcement? These are public lawyers bringing these claims, because under the Americans with Disabilities Act, private individuals can also bring ADA lawsuits. So what's the added value in you folks doing this as a public office?
I think it's important to have both of those features. I think in a law that people with disabilities have to have the ability to enforce the law on their own, but they may not, or organizations representing them may not have the resources that that the federal government has when you're dealing with large systemic entities. So some of our early actions were against major corporations, major hotel chains. A lot of the early complaints we got were against hotels, because people with disabilities were traveling and were, either because they used service animals, were being denied access to hotels, or they didn't have enough accessible rooms for people who use wheelchairs, or didn't have the features that a deaf person needed to be fully accommodated in a hotel. So if you are, the importance of having a federal structure do that is you can go against a corporation that has 700 hotels in the United States and bring about systemic change that will affect all 700. Or to have the ability to, litigation is not the easiest way to resolve disputes. It's really a means of last resort, I think, because it can be very messy, time-consuming, and expensive. And you have to sort of stick to your guns. We had one case in a major hotel that had 1,000 doors. Every door was done wrong under the ADA. We required that hotel to change all 1,000 doors. That's something the federal government is going to have the ability to do that a small private individual may not have the staying power to ensure that that kind of change results. The reason that happened in that case, it was a newly constructed facility. It was, and it was done incorrectly, and it was important. Door width, it could not be a more important thing for a wheelchair user to get into a door. The other thing I think that it's important is it sends a message. Most of the compliance that has occurred in the United States under the ADA has been voluntary. It's been entities understanding what they have to do and doing it. But the stick that makes them sure that they'll take the voluntary actions is knowing that there are lawyers there, that the federal government will enforce it, and that there are the president or the attorney general or officials of the United States government will say, this is an important law, we are going to enforce it vigorously, so you should comply voluntarily. I think you need that stick in order to make the voluntary compliance bloom.
1 minute left with you. If I could trouble you to just say, is there any other advice? You've got the minister sitting here taking notes and eagerly listening. Any other advice you would give the government of Canada as they're designing our legislation on what to include to make it effective, to make enforcement work?
I think the issue we're all confronting today is accessible technology, accessible websites. The way we all live and do business and are educated is totally different. And so I think spending time thinking about those standards and how that works, whether it's in education, in your universities, whether it's at kiosks at your, where you buy your tickets at the airport, whether it's the phone systems, whether it's your emergency systems, whether all of these aspects, in this day and age, you have to think differently. And it's really the same kind of concept of making a building accessible. You're making the the environment, the technological environment accessible. And I think it's important to get a grasp of that right now at the beginning of the law.
Thank you so much for interrupting your holiday to spend time with us, and I hope you're able to stay online, and I will check my email for that sangria after, to share with everyone, of course. Our last speaker from the U.S. is actually a Canadian from Saskatchewan who's moved to California, Lucy Greco. Lucy, unmute your mic if you wouldn't mind, and just let me know you're there, please.
Done that, and it's Alberta, not Saskatchewan.
Oh, I forgot that. I thought it was just anyway, let me just tell you.
Lucy and I went to summer camp together.
And as I understand, you play girl ball against each other, and I'm not asking who won. But Minister, the importance of success comes from not only enacting and enforcing accessibility standards, but by finding and using every lever of power that the federal government can grab and use to generate and leverage more accessibility. And Lucy is going to give you a fabulous illustration in an area that I know your government's been exploring, and that is how to use the attachment of accessibility strings to purchasing power, whether it's procurement, or infrastructure spending, or loans, or grants from the government. Lucy, just so everyone knows, Lucy Greco is in Berkeley, California, works for the University of California, which is a series of universities all together, and her official title, she tells me, is the Accessibility Evangelist. So Lucy, let me begin by asking you, how big is the University of California? How many campuses? How many students, and what the heck is an accessibility evangelist?
So my role is to help the university themselves recognize where accessibility barriers are and help diminish those roles and give guidance and give them direction in which we should go to make ourselves a more accessible university. So I specifically work for the University at Berkeley, and we are a campus of 35,000 students with over 8,000 faculty and staff. But that expands across the entire state to a system of 285,000 students and 198,000 faculty and staff. And we have 10 universities across the system, 4 medical centers, which are fully functioning hospitals, which have outreach across the state in various everything from Mediclinics to big research facilities like the University of San Francisco. And we have 4 national laboratories as well, which were contracted with the federal government to do things like research in physics, research in biomedical. So we're a very large system. And for us, even though the ADA has been around since 1991, we are still very new at the accessibility game. It's still something very different and difficult for us to try to understand and work with. So to come in and look at different parts of the system and say, oh, so we need to buy an HR system that people can use to clock their vacation leave. How do we make that system accessible? Is there something on the market that will actually meet our needs? And if it doesn't, how do we make it meet our needs?
In the process, and tell us about the standards for accessible purchasing of goods and services that you've been involved with at the University of California.
Definitely. So one of my roles has been to be the person who writes the policies, writes the guidelines. So one of our first initiatives was to write purchasing guidelines, because we know that a majority of the software, the technology we use, everything we use is stuff we buy. And if we don't buy it accessible, the way our system works here in the US is that if somebody uses our technology and finds it inaccessible to them, we're responsible, not the people who manufacture it. And to me, that's actually a huge, huge flaw in the system, because we have no recourse when we have to buy something that's inaccessible to go back to them, except in our purchasing power and our leverage. So I've been really strongly pushing and advocating at UC that we make our our vendors that we're buying things from be the ones responsible. We give them the onus of making their products accessible with help, which is really, really important. So for example, we went to a vendor that we were going to be purchasing our email and our document creation suite, so forth from them. And we said, we need this product to be accessible to everyone in our community. We need people with disabilities to be able to use it. We need people, with cognitive disabilities to be able to, what can you do for us? How can you help us fix it? And they're like, we don't know how to make a product accessible. We can't do that. So it was my role as the expert in accessibility to work with that vendor and help them find the way to make the product accessible. And today they're actually winning awards for their accessibility. So it's a long process, but it's a partnership. We gave them information they needed, and I think, Carla, specifically to your government, it's your role to help find experts to help people achieve the accessibility they need. They can't do this in a vacuum. It's not something that happens without individuals participating, without people who know what's going on, and those people should be people with disabilities. We come from when I talk about people with disabilities, I'm disabled myself, and I am in a group of people who is poorly underrepresented in the workforce. This is an ideal opportunity to get people in the workforce who are disabled, because use our expertise of our own disabilities to help inform and educate those vendors providing products, those educational institutions who don't know how to become accessible, help them find and set up their own pathways and their own guidance.
Let's get some examples. So University of California, which has got some pretty hefty purchasing power, has you write standards or requirements that you require vendors to meet if they want to sell to you. And if they don't sell to you. So first, tell me some examples of products or companies that you've inspired or caused to change the accessibility of their products. Can you give us a couple examples?
Sure. You have to realize I'm treading in very delicate territory here because I'm not allowed to endorse anybody. That's it's a state law that I'm not allowed to endorse companies. But we've worked with companies like Google. We've helped Google specifically look at their accessibility and determine where they're failing. And we specifically point out to them what we need them to fix. I'm currently working with a major software distribution and software development system, GitHub, with them, telling them where their accessibility is. It's a tool used by developers, but it's more and more frequently being used in education for students. And it is horribly inaccessible, but within the past 8 months, since we've actually had a relationship with them, where that relationship was, I provide them bugs, they fix them, it has improved tenfold. It's still got a long, long way to go, but there is definite improvement just because we've provided them the assistance. And just so you know, David, there's a significant pause, so wait for your mic to come on.
So tell us, did Google change their practices as a result of the intervention of the University of California?
I would personally like to think so, because when we first started working with them 4 years ago, I couldn't use any of their products. And I specifically was very vocal to them in our contract negotiations about the fact that myself and other blind people couldn't use their products. They had, a very small accessibility team, maybe 2 or 3 people. They were just getting started. And today they have a massive accessibility initiative. They have, I don't even know how many people on their accessibility team. They have accessibility embedded in all their project teams. And it's actually, and this is me speaking, not the university now, it's my preferred mechanism for creating documents and collaborating with people. So they've improved.
Lucy, can you, we just got a couple of more minutes left. You've seen an impact. Have any other organizations adopted the standards for procurement that you've been involved or University of California is using?
Yes, actually, where you and I first met was at the CSUN conference. And from that conference, I presented our specific purchasing guidelines, and at least 3 other universities that I'm aware of now are using maybe not the exact same wording, but the exact same methodology for achieving accessibility in their products. The benefit to that is previously we were all looking for accessibility, and we would go to the vendors and we say, you need to be accessible and you need to meet these guidelines, and they would present us with what was called a voluntary accessibility template. And that voluntary accessibility template was literally that. It was something they volunteered. They could say what they wanted about their own accessibility, and there was no enforcement behind it. Part of our standards right now are that you have to test and you have to ensure that the product actually does match what the vendor says it can do. And if we all are asking for the same thing, vendors know what to provide us with. If one university says, oh, we need screen reader accessibility, and another university says, oh, we need keyboard accessibility, vendors don't know where to focus on. But if we all say we need both keyboard and screen reader accessibility, that's something that they can focus on. That's an actual direction. So that's a hard, everybody wants the same thing is really important. And we really do all want the same thing. We want accessibility, but we've got to all state it the same way. And there's got to be, there's got to be a path to the accessibility that's followed. Right now, everybody says, oh, we need something that's accessible. What the university is doing is saying, we need to move forward accessibly. We're not looking back, we're always looking forward. And that's really important. Although when it comes to things like infrastructure, yes, it's important to put a ramp into a building that doesn't have a ramp. But if you're building a new building and you forget the ramp in those guidelines, it's going to cost you a lot more. It's the same thing with software and technology. It's interesting to hear my colleagues talk about, the cost benefit analysis, when if something is designed accessibly and people with disabilities are involved in the design process of products, additional cost, the accessibility, because it's just the cost of developing the product. Adding the accessibility later on and adding the need for people with disabilities to access it afterwards has been proven to cost 15 to 20 times more than just thinking about the accessibility. And ultimately, the thing we are always finding, and I'm going to quote one of our professors right now who just did some major improvements to one of his courses. He goes, I've gone through, I've made all these fixes, and I'll be damned if the course now isn't better than it was before. If I had just thought of this at first, students wouldn't have had to struggle so much to go through the interface that I created without thinking about these points. And it's always that case. It's always when it's accessible, it's easier for everyone to use. In technology, we use the term electronic curb cuts. You think about the fact that curb cuts assist mothers in strollers as well as people in wheelchairs. Well, making things accessible is going to make interfaces easier for everyone to use.
I appreciate your all of what you've been able to cram into the time we have together. Folks, the last place we're going to turn our attention to is to the state of Israel, and we have 2 speakers on the line. Israel passed its first disability rights law on equal rights for people with disabilities in 1998. And in 2005, it added to that law a chapter on accessibility. We're going to first hear from a speaker to talk about developing accessibility regulations under it, and then we'll hear from a speaker involved in enforcement of those regulations in Israel. So our first speaker is Tzvia Admon. Tzvia is a lawyer who also teaches at 2 different universities in Israel. She's also involved in teaching accessibility auditors, training accessibility auditors in Israel. She has a master's of law in disability rights and has been active in the field for 20 to 25 years, going back to when the movement first began to try to get this kind of legislation passed. She, most directly for our purposes today, she was retained by the Disability Rights Commission in the Department of Justice of the Government of Israel to develop their customer service accessibility standard. Tzvia, if you wouldn't mind turning the mute off and let me know you can hear me. Good morning, and for you, I guess it's close to good evening.
It's good evening, yes.
So tell us first, can you tell us a bit about the accessibility chapter in the disability rights law? What does it require, and what kind of accessibility standards have been developed under it?
Okay, the accessibility chapter, first of all, forbids discrimination in public places and public services. It puts a duty on owners of locations on buildings and public services to make all these services and locations accessible. Now, the chapter encompasses practically every area of life, from health to education to transport. To the transport is in another chapter, but every service given by either the government agency or a private entity, from entertainment to sports to financial services, even religious services, have to be made accessible, both the locations where they are given and the services themselves. Now, until now, about 20 sets of regulations have been enacted. The three major sets of regulations which serve as a foundation for all the other sets are the regulations on customer service and two sets of regulations on accessibility to buildings, both existing buildings and new construction. Other accessibility regulations are on access to open air locations, such as beaches, cemeteries, parks, and nature reserves, regulations on accessibility to educational services. Colleges and universities have to be accessible, both their buildings and the educational services they provide. Professional training courses have to be accessible. There has to be accessibility to school buildings for children with disabilities and parents with disabilities. There are regulations on accessibility to health services, to hospitals and clinics, to public transportation, to buses, to trains, to car rentals and bus rentals, to accessible taxi services, accessible phones for customers. There probably are other sets which I've forgotten at the moment.
So talk to us now. You were responsible for developing and doing the work on the writing of the customer service accessibility, and it took about 8 years from beginning to end. So what I want you to do is first tell us the formal process, who has to approve it, and then tell us how you went about it and what took 8 years.
Okay, so the law authorizes several ministers to enact regulations in their field of expertise. So, for instance, the Minister of Health is authorized to enact regulations on health services. The Minister of Justice is authorized to enact regulations on customer services. The law tells them exactly what the scope of the regulation is, what issues they must address, and with whom they must consult. They must consult with the Commission on Equal Rights. They must consult with representatives of disability NGOs. They must get the approval of the Minister of Finance, sometimes also the Minister of Internal Affairs. And finally, they have to get the approval of the Knesset Committee on Welfare, which oversees all the enactment process. Once the Knesset Committee approves these regulations, the minister then signs them. They are published and enter into force on the date of publication or at a later date, which is set in the regulations themselves. Now, your second question was how we actually did it?
Israeli parliament.
David.
Yes.
The second part of your question, I missed it.
Yes, could you about what you did? Take us through your journey of developing these and what you learned along the way about how to make that process work.
Okay, so I wrote an early draft of the regulations based mostly on the Americans with Disabilities Act and the British Disability Discrimination Act, as it was at the time. I also consulted with several Israeli experts on disabilities. Then we sent this draft for comments to many disability NGOs and several government ministries. the NGOs had a lot of feedback to give us. So we set a round of consultations, which lasted about 2 years, until we reached a draft that we all agreed on. We then submitted it to the Knesset Committee on Welfare, but the committee sent us back to have another round of consultations called roundtable consultations, with the idea that each participant has an equal voice. At this point, we also heard from large service providers, such as banks and the Chamber of Commerce and the hotels and so on, and also from other government ministries who heard about the regulations and wanted to have a say. During these roundtable consultations, we actually discussed each and every chapter, subchapter, each word until we reached an agreement on everything or nearly everything. And then after each subchapter was finished, we submitted it back to the Knesset Committee on Welfare for approval until we had the final draft approved by the Knesset Committee. And what was the other question? Sorry?
What took so long and what took so long and what did you learn? What advice can you give the government of Canada about how to do this to make it work?
Okay, it took a long time because of two reasons. One is the scope of the regulations, which really encompass nearly every service, except those services which are under the authority of other ministers, such as health or education. Every other service, from services given by the government, welfare, courts, prisons, to services given by private entities such as restaurants, hotels, and cinemas, they were all dealt with in the regulations. And we actually had to divide the regulations into two parts. One part deals with general accommodations, which apply to every kind of service, such as policies, practices, and procedures, and internet services and information accessibility. And the second part, which looked particularly at certain services and asked which accommodations are reasonable and relevant to them. That is why it took so long. Now, what I would recommend, I have several recommendations actually, which I thought about. One is to ensure that the body which oversees the enactment procedure has a clear view what needs to be in the regulations and what doesn't have to be in the regulations, and is deeply involved in the process and is willing to be decisive, to make decisions on these issues. And the second point, which is related to the first one, is to focus on those issues which are central to the regulations and keep other things like technical specifications of accommodations, like what are the specifications of an accessible table, to standards, to technical standards to be developed separately. Also think about those provisions which are more appropriate for guidelines rather than regulations. For instance, if you have a provision that says that a teacher or a guide in a professional training course has to reserve a place, a physical place near him or her for a disabled student at all times, well, this is not always possible, especially if they go out on a hike or a visit to the museum. So this kind of provision is more appropriate for guidelines. And if you focus on these major issues and form a consensus around them, you can speed up the process considerably. Now, another thing that I would recommend is to distinguish clearly between those duties you place on government bodies and public bodies and those you place on private entities. I personally believe that government bodies, public bodies, and perhaps large corporations have a great responsibility to accommodate the needs of people with disabilities. And so the duties of accommodations on them should be slightly higher than private entities. Especially, small businesses, they don't really have to be up to the standard required from government bodies. And perhaps the last point is to maintain flexibility in the regulations themselves, so you could introduce new technology, especially new assistive technology, into the regulations without having to overhaul them or review them periodically to reflect the change in technology. We did this in our regulations. In nearly every chapter and subchapter, there is a provision that says that service providers can use any reasonable accommodations. alongside the required recommendations, which are the minimum requirements for every service and particular services.
Svea, I want to ask you've referred to regulations, and I know they're enforceable. And you've also referred to standards. What's the difference between the two? Who makes the standards, and what's the relationship between the two?
Okay, so standards are technical specifications of accessible measures. Accessibility standards are technical specifications. For instance, what are the measurements of an accessible table or a ramp or a light switch? How are they supposed to be? Now, these standards are developed by a non-governmental body called the Standards Institution of Israel, the SII. It's a non-governmental body. It works through technical committees comprising of experts, technical experts, representatives of government ministries, of the commission, of the industries involved, and people with disabilities. They develop these standards. Now, standards in general in Israel are not mandatory. They're voluntary. They can be made mandatory in two ways. One way is if the Minister of Economics issues an order that declares a certain standard to be mandatory, an official standard. The other way is the way we use in the regulations is by referring to the standards through the regulations. So for instance, we said signs, accessible signs have to comply with standard 1918 part 4. That made the standard mandatory in that particular instance. That is the way to make standards mandatory in Israel.
Thank you very much. And I'm now going to turn our attention to our last speaker, and that is to discuss the issue of enforcement of Israel's accessibility legislation. In the Department of Justice, there is a disability, a Commission on the Rights of People with Disabilities. Bila Berg is on over the web with us today, and she is a lawyer with the Commission. She's legal advisor to, and part of her functions includes advising those who do the enforcement in the Commission. So Bila, hello and welcome, and please unmute your microphone and tell us what the powers of enforcement are. How is the Israel regulations on accessibility, how are they enforced, and how does it work?
Hi. We have a combined enforcement model. The Commission for Equal Rights of Persons with Disabilities was empowered as a dedicated body responsible for enforcement. The Commission is empowered to file civil claims, class action suits, and criminal indictments in cases of lack of accessibility and discrimination. We also have established 2 additional enforcement mechanisms. Regarding new constructions, we have created a new profession, a licensed accessibility expert, in order to apply for a building or occupancy permit and business licensing. It is now required to attach a certificate by licensed accessibility expert. The Commission inspectors conduct inspections at the planning and Commission building committees and examine whether the permits granted properly assure accessibility matters.
What, in terms of the staff of the Disability Rights Commission, there are inspectors or auditors. Tell us how many there are and what do they do?
We have about 12 inspectors, not including our accessibility complaint staff, which are apart. The inspectors authorized to issue accessibility orders that require the carrying out of accessibility. They also have investigative powers. They are empowered to enter public places, require organizations responsible for accessibility to provide information about accessibility, and the directors responsible for their accessibilities. Of course, the result can be file civil suit or indictment.
So we're clear, they can go to a business or an organization, they can actually inspect how accessible it is that right?
Can you repeat the question? I don't hear you.
The inspector can actually go to the place where a business or an organization is and inspect the place and then issue orders if there's a lack of accessibility.
Yeah. Actually, the inspectors carrying out the inspections and monitoring in two ways. Some requirements are enforced by writing letters to the obliged bodies. For example, every public place have to prepare a list of buildings or services that they have to make accessible, and they are responsible for that. And requirements such as this list are enforced through correspondence. But other accessibilities obligations do involve field inspection by the inspectors. The inspectors use checklists of requirements, which they must check on site and mark each of the defect there is in this site. For example, whether the site has an elevator and whether the elevator in a certain size and it's not enough. They check also if there is a floor announcement. The inspection includes both building and service accessibilities. And also they check accessibility of nature sites and places other than building, such as beaches or playgrounds, transportation or communications, etc.
Now, thank you. Just so people have a point of comparison, Bila told us that Israel has 12 inspectors for the state of Israel. Ontario has 5 inspectors or directors for the province of Ontario, just to give you the current point of comparison in terms of actual staff to perform comparable functions. Ontario also has others who can do delegated staff, but that's the number that they've given us. Bila, talk to us about the members of the public can phone or contact the disability, the Office for Rights for People with Disabilities in the Department of Justice. Tell us what happens if somebody with a disability calls to report an accessibility problem. What happens? What do you folks do with that?
Individuals have also the right to bring accessibility claims privately. However, they may also file an accessibility complaint with the Commission. The Commission is empowered to file a civil suit, class action, or criminal indictment based on such a complaint. But we also sometimes we just figure out what is the complaint about. There are many people that call us. They can call us by email, phone, through the Commission's website, in any contact way that is available for them. Actually, we have 5 employees handling accessibility inquiries. and they represent them if necessary. We don't get only complaints of people. They can call us also to consult how to make a place accessible, and the main aim of us for MOS is to solve the problem of the applicant, either by representing them by phone or by letter or by any correspondence. And sometimes if we have a decision that there is a good case, we represent them in court.
Take obviously the law is setting out new accessibility requirements, but as in any country, that doesn't mean that everybody's made the changes they need to make to become accessible. In your experience, how much of a difference does enforcement make to get organizations to actually change what they do and become accessible?
I believe that enforcement made the change in Israel. We see really considerable change in the attitude toward the warning letters from our inspectors and the orders issued by them. In the vast majority of places where enforcement is carried out, the orders are complied with. Only the minority that does not comply with the order is served with indictment or a lawsuit. And I think that this is a big success.
Finally, we have our minister who's going to be leading the creation of Canada's new accessibility law. Are there any other advice you would give her government on what to do to ensure that there is effective enforcement in the law?
I believe that the method we are using is a good one. The only element I would add is that of administrative fines, which may save enforcement resources, part of enforcement resources, and provide additional deterrence. I think this is the one thing which I would change in this is my recommendation.
Much. So let me now turn to the last couple of minutes and perhaps try to bring together for Minister Qualtrough and Deputy Minister Sterling and for all of us some of the common themes that we've heard that may assist. I think we've learned that structuring the development of accessibility standards and rules by having people with disabilities in the room with a representative of business and government is absolutely critical. They can't be sent to separate rooms to give government advice, or their voices won't be effectively heard. The dependency on the disability community to be able to share their experience and their advice is absolutely pivotal to success. And yet, in a country as big as Canada, with a population spread out over so much land and over 7 time zones, for a government to simply expect that we will send in our email, our comments, I'm certainly not suggesting that's the way this government's approaching it. Your outreach has been extremely commendable, but in the structure of an act, the just notice and comment procedures may work very well for business, not so well for people with disabilities. We heard from Val Piche about the importance, and it was under the leadership of her, the minister she worked with, that Ontario went from having standards development committees where people with disabilities were in the minority to when they were in a position of an equal number of seats, and that made a helpful difference. The government's already announced that they've heard the message that enforcement is really important, and it's commendable both that the government's heard it and echoed it. But what I think we've learned from some of the messages we've heard today are things about if enforcement is left to private individuals, it's just a burden that won't work. if the combination of public enforcement and private enforcement, the experience both from Israel and from the United States of having government enforcers who can bring strategic cases and who are tied into hearing complaints from the public, not that they're bound to follow, but that they can be enriched and informed by and can act upon, is extremely important to making that work. And we heard from Jennifer Howard that there was a concern as the Manitoba legislation was being developed that they didn't want their Human Rights Commission's functions to be weakened. And the government was alive to that. Ontario's experience was that we had the same concern, but the year after our Disability Act was passed, the enforcement of our Human Rights Code was privatized, so that the Human Rights Commission was taken, the Ontario Human Rights Commission was taken out of the role of investigating and litigating individual discrimination cases. In many ways, the disability community in Ontario has not recovered from that change that took place 11 years ago, and it set us back in being able to battle barriers one at a time, something we will always have to do somewhat no matter what disability law we have. I think the message that we've heard from the United States is that the government can benefit from is both finding all the levers of power and learning to use them and learning to use them creatively. Minister Qualtrough and her government did a roundtable on how to use the procurement power, which is an excellent thing to explore. We've heard from the University of California how much of a difference it can make with tiny little players like Google to change their products. We can make a huge difference. We've learned, however, that the importance is that it's more effective if the same requirement is echoed by multiple purchasers so that businesses can have one standard to meet. And we heard from David Capozzi, the executive director of the Access Board, that one of its functions is to set standards for certain kinds of procurement. We've learned from our very first speaker, Thea Curdy, that even in something as that you'd think we'd already have gotten right, how to design a building to be accessible for people with mobility and other disabilities, that we've got a long way to go, and there's a real need for federal leadership, that a national building code, drawing on what she said and adding to it, a national building code that isn't weaker but actually stronger than what others have, that actually sets out what we really need, is one which provinces may well just opt into and use. We've also learned that solutions may be found in a number of cases here in Canada, such as some of the ideas we could cherry pick from some of the municipal building codes. But architects and building designers, just like the customers who sell products to the University of California, no doubt don't want to have to learn and respond to multiple different requirements from different organizations. They'd rather one strong requirement universally applied, that if they meet it, they know everybody, they know that they're meeting the needs of everyone. That message can be drawn from what we heard from Lucy Greco at the University of California, and also from Thea Curdy talking about buildings here, and it's amplified by the work of the Access Board in the US. We've learned, I believe, from all of our speakers about the important role of embedding the right measures in government, in the legislation. So, for example, we heard from Val Piche that because this touches every department and every ministry, it's important to include in the mandate letter of each minister specific directions so that this doesn't, as Charles Beer put it, fall to the side when another issue takes over as the front political issue of the day. We have lots in Ontario that we can be proud that we've accomplished, but Minister, this is one area where we've fallen down. And in fact, I can tell you that my provincial coalition that I lead actually asked all three political leaders in the 2014 election to promise that if elected, they would do what you heard Val Piche explain from the point of view of chief of staff of a minister would be helpful to include this accessibility directions on all the government's obligations to its ministers. We actually got a promise to that effect, but actually haven't seen it materialize in all the mandate letters. So you might want to think of something irregular. This is not something that may have been floated anywhere before this very gathering today, but building into the legislation a requirement that mandate letters include accessibility directions, not just for the minister who's going to lead this law, but for all the ministers. Because one of the messages, and with this, I think I want to wrap up also because we're about to run out of time. One of the messages that cuts across everybody at the table and everybody who's taken their time to speak to us from all around the world. This is a law, Minister, that you will be leading, but that will last long beyond the service of any minister or any term of any government. We've had Jennifer Howard, who's talked to us from Manitoba, who wrote a law, and now there's a different party in power who voted for it and who's charged with responsibility for implementing it. So designing features to make the law endure well past the excitement of those who vote for passing it, well past the time when the people in the parliament or in a legislature were even there when it was passed. That is the challenge, and the ideas we hope we've given you today will help you do that. I want to thank all of our speakers. I want to thank the Alliance for an Inclusive and Accessible Canada for entrusting me with the opportunity to chair this event. I want to thank the Government of Canada for its generous grant to the Alliance. I want to thank all the Alliance volunteers who helped pull stuff together and staff. I want to thank the amazing staff at the Inclusive Design Research Center at the Ontario College of Art and Design University for making this technology work, which is unbelievably fantastic. It worked. And I want to thank all our viewers for taking the time to watch this. So we sign off now and look forward to strong accessibility legislation in Canada. Call on 7 more provinces to take action across this country, and hope other countries can learn from what we learned here today. Thank you all very much.
Thank you, David.